Good morning, everyone. I think it's time to start. Please prepare your translation devices because some of the speeches will be in Latvian, and I will also switch to my native tongue after a short introduction because it's more comfortable and it's more secure not to say some things I might regret afterwards. Which never happens in the native tongue, of course. But it's a great pleasure to see everybody here, and thank you for coming to participate in our conference. And now I think I will switch to Latvian to give some introduction about the idea of the conference and to give an overview of how we are doing in Latvia regarding the topic we are discussing today.
The three topics of the conference can be united in one sentence. How the judge on a daily basis establishes it on values and how it can be connected with national identity. The idea of the conference is the following. 20 years ago, we together, many Eastern European countries, joined European judicial area, and I believe 20 years is a very good time to look back where we are at the moment and how we are doing. And I believe that this distance of 20 years is also big enough in order to focus our view in an objective and impartial manner. Looking back at the statistics on the screen, yes, of course, how we were doing. Latvian judge applies European justice system actively, and at the moment it is already a routine work. And whatever and however we did at the very beginning, because we had to get used to something, to a habit, and it has been enough time to establish it as a routine. And it is very good demonstrated by the intensity of preliminary ruling application. And as you can see, the first years in the EU for Latvia has been with very few applications, namely application of dialogue in preliminary rulings of EU, because this transition was not easy for any judge, but it has developed gradually, and already for 15 years we can say that the dialogue is being applied, and this dialogue is active. Also, statistics shows two things. First, that the majority of application of EU law is in administrative courts. Second, civil cases that lags behind criminal administrative cases, and for criminal cases, the least application of preliminary rulings. It would be interesting to learn how these figures are for other countries, but this is Latvian statistics. Also, the statistics show that indeed the Supreme Court has the biggest role in application EU ruling. The second slide, EU fundamental laws rules are indeed established in the Treaty of the European Union, and they are directly in our hands, because every judgment has to be based on EU values and their implementations, because even if any question is not regulated directly by EU legislation, however, the question cannot be contradictory to overarching values of EU legislation or constitution of the country in question. That's why I hope and believe that today we can talk how we have been doing throughout those 20 years, because every country chose its own road. We had our own peculiarities and we had our own challenges throughout those 20 years, and how we solved those issues. And I urge you to be very active throughout the conference in order to acknowledge as well as develop the values of EU that are common for all of us. And as first, I would like to give the floor to Koen LENAERTS, Mr. Koen LENAERTS, who is the President of the Court of Justice of the European Union, and he will address us through a video.
Dear President STRUPIŠS, dear colleagues, ladies and gentlemen, I am extremely pleased to be associated over this video link to the work of a very important conference organized by the Supreme Court of Latvia on the occasion of the 20th anniversary of Latvia's accession, along with 9 other member states, to the European Union. The Court of Justice of the European Union has celebrated through an important conference on the 2nd and the 3rd of May of this very year 2024 this accession, marking thereby that all 27 member states of the European Union are participating in the Union as equals who respect one another, who work with one another in links of solidarity and mutual respect, mutual trust. It is like a mosaic which is not complete when one piece is failing. Each piece is just as important as any other piece, because any piece failing will make that the mosaic is not beautiful, is not complete. And that is exactly the image of the European Union. That's also the spirit in which we are together today in this conference organized by the Supreme Court of Latvia. And the theme of the conference lies at the heart of what European Union law really stands for. The Court of Justice has held in its full court judgment of the 16th of February 2022 on the conditionality regulation that the very identity of the European Union as a common legal order lies in the compliance with the values of Article 2 of the European Union. And these values, human dignity, freedom, democracy, respect for the rule of law, for human rights, in a society characterized by pluralism, tolerance, equality, in particular between women and men, protection of minorities, and also solidarity. All values which member states recognize they have in common, that is, values which really format the society within the member states and between the member states, the society in which we live together as Europeans. These values reflect the unity for which the Union stands, but these values at the same time are fed by the diversity of national traditions, languages, historical backgrounds, regional differences, all sorts of approaches to living in society which enrich the unity and give content to the values which we share. That is the deepest sense of the motto, united in diversity. In some languages it is reversed, in diversity united, in der Vielfalt geeint. The diversity comes first, the unity is constructed as the values which we share. National judges play a crucial role in upholding these values within the member states and also in legal relationships between the member states. And it is good at the start of this conference to realize that the national courts are the main courts of European Union law. It is not the court I have the honor to preside, the Court of Justice of the European Union. You'll see why I'm saying this. It is the national courts, and only the national courts, which decide litigation between private parties. Litigation whose outcome turns on the correct application of union law. The same holds true for all litigation between, on the one hand, a private party and on the other hand, a public party of a member state. Think, for instance, about criminal cases where you have the public party, the prosecutor, against the private party, the accused. Or tax cases where you have the taxpayer, private party, against the tax administration, public party. Or all aspects of administrative law, when it comes to asylum and immigration decisions, when it comes to authorizations granted in compliance, hopefully, with the EU law, rules on environmental protection. All these cases are of the exclusive competence of the national courts. To give a few examples of cases which move between two private parties, think about all the employment law cases between an employer and an employee, or insurance cases between an insurance company and an insured person, consumer protection cases which move between a consumer, private party, and another private party, a professional seller. All these cases are of the exclusive competence of national courts, which apply and enforce union law. That is why in French we say that the national courts are the juges de droit commun. In English I would translate that as the courts of general jurisdiction of union law. The Court of Justice of the European Union only has conferred jurisdiction, mainly as to the relationship with national courts, in order to interpret union law, so as to make sure that the national courts, when they apply and enforce union law, do so in conformity with an interpretation of these union law rules, which is valid in all 27 member states. And of course, the uniformity of interpretation of union law in all 27 member states is a cornerstone concept of union law, because it is the ultimate guarantee that member states and their citizens are equal before the law, in this case equal before union law. And that is why the trustful relationship between national courts and the Court of Justice of the European Union, whereby national courts refer questions of union law to the Court of Justice, which triggers a debate before the Court of Justice, in which all member states are entitled to intervene, to participate, because the interpretation which the Court of Justice will be led to give is valid in all 27 member states and not just in the member state whose judge it was referring the case to the Court of Justice. And indeed you should know that when you as national courts formulate questions of interpretation of union law, or, as the case may be, questions the validity in terms of compliance with higher union law, such as the Charter of Fundamental Rights of the European Union, of one or another provision of a regulation or a directive or a decision, in all these cases, it is the national court which sets the stage, the framework within which the question of the proper interpretation or the validity, as the case may be, of union law will be debated before the Court of Justice by all those who want to participate in this debate. That means all the member states, the parties in the main action, the institutions of the Union, and so forth, leading up to a common understanding of the values, principles and rules of union law, which will then thereafter again be applied and enforced by the member state courts. That is why the Court of Justice of the European Union sees itself in a network relationship between equals with the national courts, and in particular with the national Supreme and Constitutional Courts. It is in the interaction with them that union law is developed, is further elaborated, when specified, if you want, when it is necessary to make the rules work in the field. The national courts discover how these rules can play out in the field, what the issues, the problems might be, also in fluent interaction with aspects of national law, and submit that problem to the Court of Justice. All the other member states come in, if they want to do so, in writing and or orally, when an oral proceeding is organized, and the court will be fully informed on a pan-European level of how the union law rules play out in all the member states before making its interpretation. But the national court, which takes up the initiative of this debate, plays a crucial role in defining the terms within which that debate is taking place. And that is why a conference like this one today is so important, because it's an exercise in a common awareness of this EU dimension in the daily operation of national courts, and in particular national Supreme Courts. And you will understand easily that the primacy of union law, which is in fact the ultimate guarantee of uniformity of understanding, application and enforcement of the rules made in common, in order to guarantee this equality already referred to between member states and citizens before the law, in this case union law, that all of this can only play when the national courts are independent, impartial, operate in compliance with all fair trial rules, and thereby grant effective judicial protection to the rights and obligations flowing from union law as such in the national legal system. That explains why the Court of Justice can rule, has jurisdiction to rule, on the systemic requirements which national judiciaries must satisfy in order to be able to play their role in upholding union law in the national legal system. That is, union law as part of the national legal system, not as something which is foreign and external to the national system. Union law is integrated in the national legal system through these principles of direct effect of union law provisions, the primacy of union law, the uniform application of union law, the equality of member states and citizens before union law. All these principles can only be upheld when the judiciaries of the member states satisfy the value of the rule of law in Article 2, as further specified in Article 19 of the Treaty on the European Union, which obliges the member states to institute a system of effective judicial protection of the rights and obligations flowing from Union law, as well as Article 47 of the Charter of Fundamental Rights of the European Union, being a fundamental right to effective judicial protection. I would like to illustrate what I've been saying so far by referring to 3 ground chamber judgments of the Court of Justice of the European Union on references made by the Latvian Supreme Court. And it will immediately illustrate what I have said so far in more conceptual and theoretical terms. The 3 cases I'm referring to is first the Petruhin case. It's a case involving an Estonian national who is a permanent resident of Latvia. And his extradition is sought by Russia. The case plays in 2015-2016. And the question arose, since Latvia is not extraditing to a third country its own nationals, does union citizenship also require that the same applies in favor of citizens of other European Union member states, citizens of the Union? And the court takes here an absolute position of principle. It says that when Latvia is not extraditing its own nationals to third countries, it must ask the member state of nationality of that person whether that member state has the same rule and permit that other member state to issue a European arrest warrant to get its national back, so that this other member state can institute, if need be, criminal proceedings against that person. So this reference for a preliminary ruling by the Latvian Supreme Court led to the landmark judgment Petruhin, and now everyone speaks in European Union law jargon of the Petruhin mechanism, whereby a member state must always request first the position of the member state of nationality of the union citizen resident on its national territory before considering extraditing that person to a third state. So it's a very important development which has been further specified in subsequent cases. Another aspect is a ground chamber judgment in a wholly different field. It's a matter of public health care, where an Italian national joined his Latvian wife in Latvia, and they lived together in Latvia. However, the Italian spouse was not economically active. And the question was, does this person have the right to be affiliated to the public health care system? The public health care system, which in fact is part of the general taxation system, and which leads to universal health care for everyone, in principle on a free basis, the system being financed by general taxation means. And the court, interpreting the union law rules on the coordination of the national social security systems of the member states, holds that certainly this person, this Italian national, as union citizen, has the right to be affiliated to the public health system in Latvia, but that this affiliation should not be free of charge, because another union directive, 2004/38, makes clear that when a union citizen is economically inactive, even if it's as a member of another union citizen's family, that person must be self-sufficient for his resources of living and for a full coverage in the health insurance. And combining these two, the right to be affiliated with, on the other hand, the need not to be a public charge for the host member state, in this case Latvia, has led to the holding that the person had the right to be affiliated, but he had to pay for it. And finally, a more technical case decided by the Grand Chamber in 2023, the SS Hess case, which was a case of characterizing public schemes of financing the production of electricity, and where the court said that the establishment of a state aid scheme cannot result as such from a judicial decision. It was a rather complex case in which the court had finally to decide what is state aid and what is not. And the case clarifies that state aid, of course, is always an advantage for an undertaking financed by public means, or at the very least by means which are stemming from private sources, but which have been collected on the basis of a public law obligation, and the funds remain thereafter under public control. So you see three very different subject matters. A criminal case about extradition to a third country of a citizen of the Union, a national of another member state than the member state whose court is to decide the case. A case on public health costs and public health insurance, affiliation to a social security scheme in a member state other than the member state whose nationality one has, an Italian in Latvia. And third, a state aid scheme in the sector of regulating prices in the energy sector. That illustrates the full scope of union law in all the different fields. National courts will only be reliable partners in the network of courts that uphold union law when they are courts within the meaning of Article 19, independent and impartial, operating in compliance with the Fundamental Rights Charter, and in particular its Article 47. We are together in this, and that is why it is extremely appropriate that this conference, organized by the Latvian Supreme Court, focuses on the theme of national courts as European Union courts. I wish you a very successful conference throughout the day. Thank you.
Paldies, Prezidentam LENAERTS.
Thank you very much, President LENAERTS. And the next speaker will be our special guest, the President of the Supreme Court of Ukraine, Mr. Stanislav KRAVCHENKO. Please, the floor is yours.
Good day to the President of the Supreme Court of Latvia, Aigars STRUPIŠS, and a good day to the President of the Court of the EU, Koen LENAERTS.
Хочу щиро подякувати за запрошення. Для мене велика честь бути на цьому заході.
Thank you so much for having me here. It's a great honor to be present in this event.
Користуючись нагодою, хочу передати вам вітання від всіх українських суддів, і, зокрема, суддів Верховного суду.
Availing myself of this opportunity, I would like to extend warmest welcome from all the judges in Ukraine and especially from the justices of the Supreme Court of Ukraine.
Вітаємо вас, Латвійську Республіку, з 20-річчям вступу до Європейського Союзу, до величної і сильної сім'ї демократичних держав Європи.
And we welcome you, the Republic of Latvia, on joining the European family, the family of the European Union, and all the positive aspects that come with it.
Дійсно, шлях, який ви пройшли за ці 20 років, є вражаючим. І дивлячись на його результати, ми бачимо, що нам є до чого прагнути.
All the past that you have been through over these 20 years is impressive, and we see that we have a lot to strive for.
Але говорячи за досягнення, я хотів би закликати вас пам'ятати про те, що загрози і виклики демократичному суспільству, на жаль, існують і в ці дні.
But speaking of the achievements that have been there, I'd like also to remind you of the fact that challenges and obstacles are still there.
Яскравим прикладом цьому є ситуація в Україні. Протягом вже 10 років наша країна мужньо протистоїть жорстокій агресії з боку Росії.
And the challenges and obstacles to democracy that I mentioned is very vividly exemplified by Ukraine, where for over 10 years we have been countering Russian aggression.
Ця війна не лише боротьба за незалежність України, а й захист цінностей, на яких побудований Європейський Союз, зокрема, повага до людської гідності, свобода, демократія, верховенство права, справедливість та рівність.
This war is not just about Ukraine, it's about upholding the values of the European Union, such as freedom, democracy, respect for human dignity and fundamental human rights.
За право бути членом ЄС Україна сьогодні платить надзвичайно високу ціну.
Ukraine is paying a very high price for the right to be a member of the European Union.
24 лютого 2022 року Росія вчинила безпрецедентний широкомасштабний напад на мирну Україну, порушивши всі принципи та норми міжнародного гуманітарного права та права людини.
On the 24th of February of 2022, Russia has committed an act of unprecedented aggression by unleashing this aggression against Ukraine in violation of all the principles and norms of international criminal law.
Війна – це велике горе, це втрачені і понівечені життя людей, але ж ми знаємо, що людське життя – це найвища цінність.
In addition to all the international human rights law violations and humanitarian law violations, it brought about the deaths and mutilations of life and health of Ukrainians, and we know that life is the biggest value a person can have.
З початку широкомасштабної війни Латвія була однією з перших, хто протягнув нам руку допомоги військової, політичної, гуманітарної.
From the very first days of aggression, Latvia was the country, one of the first countries who has extended its help to us in the form of military, humanitarian and other political and other kinds of help.
Латвія надала прихисток тисячі нашим громадянам, за що ми надзвичайно вдячні.
And Latvia has provided shelter to thousands of our nationals, for which we are very grateful.
Ваша солідарність має для нас неоціненне значення.
And your solidarity for us is of primary importance.
Вітаємо підписання нашими президентами в квітні 2024 року угоди про співробітництво у сфері безпеки та довгострокову підтримку.
We support the signing of the agreement on the long-term security and cooperation between the presidents of the two countries in April this year.
Ваша країна також активно підтримує прагнення України до членства в Європейському Союзі та НАТО.
Your country is also actively supporting the aspirations of our country to be member of the European Union and of NATO.
Особливо зараз важливо для нас підтримка у вирішить питання щодо конфіскації російських активів на своїй території.
Right now, we truly would appreciate your support in helping to confiscate Russian assets in your territory.
Також дякуємо Латвії за активну дипломатичну підтримку питання про початок переговорів про вступ України до Європейського Союзу до кінця червня цього року.
Also, we truly value diplomatic support, especially when we speak of the accession negotiations up to the June this year.
Окремо дякуємо за підтримку у ініціативи України про створення спеціального трибуналу.
And we would like to extend special thanks for the initiative on establishment of the special tribunal.
Ці кроки свідчать про непохитну підтримку Латвії Україні у боротьбі за свободу і європейське майбутнє.
These steps signify the unwavering support Latvia extends to Ukraine in fighting for democracy and freedom.
Також, користуючись нагодою, хочу щиро подякувати іншим країнам ЄС і присутнім тут представникам.
And availing myself of this opportunity, I would like also to extend our gratitude to representatives of other member states of the European Union and their representatives.
Верховний суд Латвії має давню історію співпраці з Україною.
The Supreme Court of Latvia has a long-standing history of cooperation with Ukraine.
І в просуванні реформ саме в сфері правосуддя ми мали надійну підтримку і допомогу, а в ці дні вона є для нас дійсно безцінною.
And on our path of implementing reforms in the justice sector, we have been provided such support which really is important and invaluable for us.
Новий поштовх у цій підтримці ми мали 2017 року, коли стартував проєкт «Твінінг», який мав назву «Посилення інституційної спроможності Верховного суду у сфері захисту прав людини на національному рівні».
And a special impetus for such support was in 2017 when the project dedicated to strengthening of the institutional capacity of the Supreme Court was initiated by Latvia.
Хочу повідомити, що незважаючи на надзвичайно складні умови і безпрецедентні виклики воєнного стану, зокрема енергетичну кризу, ракетні обстріли, перебої з фінансуванням, надмірного перенавантаження і дефіциту кадрів, судова влада в Україні продовжує функціонувати.
I'd like to tell you that irrespective of the unprecedented challenges of the wartime, of the energy crisis, of the missile attacks and of budget shortages, of the extreme overloaded timelines for the judges and court staff, our judiciary is still continuing to function.
У 2023 році ми спостерігали достатньо дивну динаміку. Українські суди вийшли на довоєнний рівень розгляду всіх категорій справ.
In 2023, we observed a rather surprising dynamics because the courts in Ukraine again considered almost the same amount of the cases as they considered before the war broke out.
Це говорить про те, що українські громадяни, як би їм важко не було, вирішують свої справи в суді і не бачать інших способів.
It signifies the fact that Ukrainian nationals, irrespective of the challenges that they are facing, are choosing courts as the institutions to resolve their disputes.
Хоча частина українських судів залишилась на тимчасово окупованій території, частина зруйнована, та і у відносно безпечних місцях здійснювати правосуддя надзвичайно складно.
And all of this in the face of the fact that some of the courts remained in the temporarily occupied territories, some of them were damaged or destroyed, and some of them, although in the territory where it could be called relatively safe, still it is very tough to work there.
Війна змінила і категорію справ, які розглядають національні суди. І на сьогодні все більше і більше це проваджень щодо вчинення воєнних злочинів, щодо злочинів проти національної безпеки та інші категорії, які є специфічними для війни.
Because of the war, we now are considering a whole new category of cases such as war crimes, crimes against national security and other specific cases.
Перш за все, діяльність національних судів скерована на забезпечення органами розслідування фіксації воєнних злочинів, і їх на сьогоднішній день зафіксовано більше 130 тисяч.
Also, the courts in Ukraine are supporting the investigative authorities in the recording of the war crimes and the other actions at the preliminary stage of proceedings. And now we have 131,000 of such war crime cases that have been registered.
2000 кримінальних проваджень щодо вчинення воєнних злочинів надійшли до національних судів, і половина з них уже розглянуті.
National courts have received 2,000 cases on war crimes, and half of them has already been considered.
Перші 11 кримінальних проваджень вже розглянуті Верховним судом, і це дозволяє нам формувати єдність практики.
The first 11 such war crime cases have already been considered by the Supreme Court, which allows us to have the uniformity of jurisprudence, and our part is shaping it.
Але як би важко нам не було, ми свідомі тому, що рішення національних судів повинні відповідати самим високим стандартам і щоб сприймались у всьому світі.
But no matter how hard it is for us, we understand that in order for our judgments to be recognized all over the world, they need to be fully in line with all the standards.
Також, незважаючи на війну, ми в Україні продовжуємо реформи.
Also, despite the war, we are ongoing with our efforts of implementing reforms in Ukraine.
Однією з вимог до вступу України до європейської сім'ї якраз і є продовження реформ.
One of the requirements for Ukraine to join the European family is to proceed with reforms.
Уже в умовах війни нам вдалося провести загальнонаціональний з'їзд суддів України.
During the war, we have been able to have the General Congress of Judges from all over Ukraine,
Завдяки якому вдалося відновити роботу Вищої ради правосуддя та Вищої кваліфкомісії суддів України.
and thanks to that, we have been able to restore the functioning of the High Council of Justice and of the High Qualification Commission of Judges of Ukraine.
Це принесло конкретні результати, і вже в травні цього року президент України призначив 114 нових суддів.
It has yielded very specific results, and this May of this year, the President of Ukraine has appointed 114 judges.
Це той ресурс, який дозволяє нам утриматись у цій складній ситуації.
That is the resource that we need to keep going in this very tough situation.
Буквально сьогодні Верховна Рада розглядає питання про обрання судді Конституційного суду.
And literally today, the Parliament of Ukraine, the Verkhovna Rada, is considering the issue of appointment of judges of the Constitutional Court.
Безперечно, перед нами значні виклики, і в нас дуже багато роботи.
Of course, we are facing severe challenges, and there is a lot of work ahead of us.
Але ми переконані, що ми на правильному шляху, і це вселяє в нас надію в те, що мета буде досягнута.
But we are convinced that we are on the right path, and this gives us hope that we'll achieve our goal.
Тут для нас надзвичайно важлива міжнародна співпраця, і ми її постійно розширюємо.
Therefore, international cooperation is very important for us, and therefore we are continuing with our efforts to develop this cooperation.
Так, з минулого року Український Верховний суд почав готувати огляди практики Суду справедливості ЄС, і ми будемо робити це надалі.
As of last year, our Supreme Court has started preparing reviews of the jurisprudence of the Court of Justice of the European Union, and will continue these efforts.
Хоча серед правників в Україні є дещо скептики, які кажуть, а чи не дуже ми поспішаємо?
And although some skepticists in Ukraine are wondering whether maybe we are just going too fast with that,
ми вважаємо, очевидно, що ні.
we think that no, we are doing just the right thing.
І українська судова система активно працює над тим, щоб кожен суддя відповідав почесному звання європейське.
And Ukrainian National Judiciary is actively working so that we can say that the Ukrainian judge fully meets the standards of being called a European judge.
І нашими пріоритетами беззмінно залишається забезпечення єдності судової практики,
Our priorities are to ensure the uniformity of jurisprudence,
наповнення суддів кадрами,
to appoint new judges to courts,
безпека суддів,
to ensure security of the judges,
відбудова зруйнованих приміщень,
and reconstruction of the destroyed buildings,
захист інвестицій.
and protection of investments.
Шановні пани та панове, 24 лютого 2022 докорінно змінило наше життя, але не змінило наші наміри.
Dear ladies and gentlemen, the 24th of February has changed our life, but it has not changed our intentions.
Європейські цінності глибоко вкорінені в нашій культурі.
European values are deeply embedded in our culture.
Прагнення до свободи, справедливості та рівності – це те, що завжди було і об'єднувало український народ.
Aspirations for freedom, justice and equality, that is what has always united Ukrainian people.
Революція Гідності стала яскравим підтвердженням цього прагнення.
The revolution of dignity has become a vivid fact to support this statement.
А членство України в ЄС – це не просто політичний вибір, а це шлях до спільної Європи, до верховенства права, справедливості та рівності і є непорушними принципами.
Membership of Ukraine in the European Union is not just a political choice, but this is the way towards the joint Europe where the rule of law, justice and equality are the inviolable principles.
Ми віруємо в те, що Україна обов'язково переможе, настане справедливий мир, а також настане день, і Україна отримає статус члена Європейського Союзу.
We believe that Ukraine will win and that we will have a just peace. And we believe that there will be a day when Ukraine becomes a member of the European Union.
Ну і повертаючись до сьогоднішнього заходу, я бажаю всім цікавої і плідної дискусії і дякую за увагу.
And coming back to the today's event, I wish you all to have very interesting and exciting discussions, and thank you for your attention.
Paldies priekšsēdētājam Kravchenko par
Thank you to Mr. KRAVCHENKO for this address, and I would like to wish Ukrainian colleagues and you and the Ukrainian people courage and being brave in this difficult time, and the truth will win. Now I would like to invite the moderator of our first panel, that's our Minister of Justice, Ms. Inese LībIņa-EGNERE, and other participants of the first panel, Ms. Ingrīda LABUCKA, Ms. Inese Ziemele, and Ms. Sanita Osipova.
Good morning, distinguished guests, judges, members of the conference here in Riga, and this is an honor for me. My name is Inese LībIņa-EGNERE, representing the government of Latvia, the Minister of Justice, to be here as a chairperson of the first panel. I will shortly also introduce the panelists, but firstly, I'm really honored to be here in the 20th year of full membership of Latvia in the EU and a full membership of Latvian language as an official language of the European Union. So this is also my honor here, together with the panelists, Latvians and Europeans, truly by heart, to switch to Latvian, the official language of European Union, for this first panel. and you will all have the possibility to follow the English translation. Tātad vēlreiz latviski, labrīt.
Hello, dear participants. I am very glad to congratulate you here on this first panel discussion. We have very highly esteemed panelists who have indeed been present throughout Latvia's road to European Union, as well as through integration into EU judicial system. I will introduce every panelist afterwards, but as the Minister of Justice, my task today is actually to talk about European values, how different branches of legislator, executive power together implement European values, as well as a rule of law in Europe, and can work hand in hand in a loyal dialogue of power, ensuring that those values can be felt by every person by feeling belonging to those values. Those values are alive, and they are actually prominating through dialogue. And the Ministry of Justice is actually exercising this function, representing Latvia in the justice system of EU. We also come up with legislative initiatives, thus strengthening legal system of EU by raising different issues for EU legislators to adopt. And in Latvia's model, the Minister of Justice is also the member of the Council of Justice in dialogue with other EU countries on issues related to justice system in Europe. Let us start with the panel. I will give the floor to every panelist. We have Ingrīda LABUCKA, former Minister of Justice, during the time when Latvia was just doing the homework for accessing EU, and Madam LABUCKA was also the first judge from Latvia in the Court of Justice, the EU. Then we have Sanita Osipova, former President of the Latvian Supreme Court, now Senator of the Supreme Court of Latvia. Then Inese Ziemele, Professor, Judge of the Court of Justice of the European Union, also the Chair of Constitutional Court of Latvia formerly. And finally, Aigars STRUPIŠS, President of the Supreme Court of Latvia, as well as the Chair of the of the Justice Council of Latvia. Ladies and gentlemen, we are a bit lagging behind the time, so I will give the floor to each of you for 15 minutes. I do not want to interrupt you, however, I might ask you to be brief. I will give the floor to Madam LABUCKA first, and then the rest of the panelists. Please, Madam LABUCKA, the floor is yours.
Dear colleagues, ladies and gentlemen, a few days ago, the Latvian judges in their annual meeting were discussing about current challenges. In order to find answers, I think it's worth looking back in the past and to remember how our judiciary system was formed, what challenges we had. Starting from the beginning of the awakening, most of the judges strictly supported the idea of the Latvian independence. We formed support groups of the Latvian National Front, including at the Supreme Court. I should also mention several historical decisions of the Supreme Court. On the 14th February 1919, the plenum decided that judges cannot be affiliated with political parties, including the Communist Party at that time. And the decision of the 23rd of April 1990, rehabilitation of politically repressed persons was approved. On the 11th of March 1991, there was a decision on the independence of the courts of the Republic of Latvia. Led by the chair of the Supreme Court, Guido Zembribo, the law on courts was developed, approved by the Parliament on the 15th December 1992, thus starting the reform and changing to the three-level judiciary system. What was the actual situation in the beginning of forming our independent country? Of course, the personnel problem. Of course, those judges who were not loyal and who didn't know the national language lost their jobs. Wages were low. Some left because of that. Courtrooms lacked any repair. Somewhere there was stove heating. However, the major problem was the intellectual challenge. I should remind that Soviet time laws and newly adopted laws were operating in parallel. Sometimes new legal acts were of low quality and contradictory. There were problems of qualification of judges, in particular in matters of interpretation of legal provisions and the hierarchy of legal provisions. Judges were sometimes literally following the law and not the spirit of the law. So the first major task was training of judges. Practically all the judges of that time had their educational background from the Soviet times. Their workload was enormous. However, they were willing to learn and to understand. Judges had internal discussions. The first groups had their training in Germany and Sweden. They brought new experience to share. The Supreme Court was very active. They were evaluating and summarizing the case law. So within a relatively short period of time, we managed to transform from the social thinking to the ability to operate in democracy and free market conditions. In 1995, Latvia became the member state of the European Council and the candidate country of the European Union. Democracy, rule of law, and human rights were the basic issues which had to be understood and implemented in practice, as this determines the future of our state. The main tasks in the field of the third pillar was strengthening of the judiciary, improvement of judges' training, creation of understanding of the EU law, human rights, and prevention of corruption. Unfortunately, in 1998, Latvia received a negative report of the European Commission regarding progress in the legal matters, in judiciary matters. I think that the Ministry of Justice and also the Judiciary had focused on resolving material technical problems, and there was no funding for qualification matters up until year 2000, and training of judges was financed by foreign donors and UNDP. Also, wages of judges were very low. So what questions did we have to answer during the process of accession? First, understanding on human rights. Judges were criticized for the long litigation terms, violations of the rights of arrested persons. Judgments were missing clear legal argumentation. Latvia lost first cases in the Court of Human Rights in Strasbourg. I should say that judges perceived criticism in a very painful manner. However, as the working methods changed and training improved, also the situation improved. We started evaluating complexity of cases, actions of courts, and we were looking for solutions. Second, corruption. Both politicians, public and mass media expressed suspicion regarding involvement of judges in corruption. The prestige of courts was low. Judges viewed this criticism as not justified. However, it was clear we had to establish a system strengthening the independence of courts and also conforming with the public wish for impartial and fair rulings of the court. The qualification and disciplinary colleges started acting. Judges were mastering communication skills. They were involved in discussions regarding impartiality of courts and other matters. Also, training programs were improved. I would like to say special thanks to those judges who were active in developing laws and in training students and other judges. I would like to mention the first chairs of the Supreme Court, Mr. Zemribo and Mr. Guljans, also judges Mr. Dudelis, Fridriksons, Gens, Kraus, and Namatevs, Gruziņš, Eilande, Jonikans, Vernuš, and others. Unfortunately, many of them are no longer with us. In March 2000, the European Union started official accession negotiations with Latvia, and the accession agreement was signed on the 16th of April 2003. And on the 1st May 2004, Latvia became a full-fledged member state. 20 years have passed since our judges have been performing the double function as national judges and as those applying the EU law. We are sure that we made the right choices, in particular today when the public and also judges have to find solutions for new challenges, climate change and environment, artificial intelligence in our daily lives, the aggressive war of Russia in Ukraine, and the long-term propaganda against the West, which has changed the security systems in the world. These are problems where we don't have solutions yet. Although the judiciary is working good, in some parts, like attitude to minorities, refugees, violence victims, judges sometimes do formal decisions and tend to forget about the main task to defend the rights, legal fairness and fundamental rights. I wish our judges to be smart but also brave and creative. Thank you.
Paldies Labuckas kundzei par.
Thank you, Madam Labucka, on the challenges faced by national courts when a country joined the EU. Many things were done by professional and knowledgeable people who can be remembered by us and honored by mentioning them. Thanks to them, we can continue this work because the basics has been established very strongly. The next speaker is going to be Inese Ziemele. She's going to talk about the European judge as an enforcer of the common values of the EU. Please, Madam Ziemele, the floor is yours. Good morning. Thank you, Madam Minister, ladies and gentlemen. Taking into account that we don't have too much time, I will tackle my topic. In my speech, I would like to touch upon two issues, namely Latvia's obligation and our judges' obligation by applying EU law, thus implementing the overall values of the EU, as it was already mentioned by Mr. LENAERTS. These are values mentioned in the second article of TFEU, demonstrated by the President of the Court of Justice. And the second issue will be some examples of the case law of the Court of Justice of the EU, thanks to Latvian judges, that can be considered as golden case law, impacting many other things in Europe. The Article 68 it prescribes that by signing international agreements, Latvia can delegate to international institutions some of its competencies. Thus, Latvian judge, by applying EU law, makes sure that the application will promote strengthening of democracy in the Republic of Latvia. This is our model. These are our preconditions. I have to indicate that democracy is actually the value of our constitution, prescribing that Latvia is independent democratic republic, as well as already mentioned TFEU value, stipulating that the EU is founded on democratic values. That's why our judges have to look at the scope of this principle, considering on a specific case, as well as keeping in mind the EU framework. It is important for us to interpret democracy in a unified way, but no one can exclude situations when we don't have 100% certainty. And in case of doubt whether the applicable law strengthens democracy according to the first sentence of the 68th article, we have to turn to the ESG for the judgment for preliminary ruling, or both. In Latvian, we have a practice and top methods establishing according to the order prescribed by the Constitution, and it took us all this time to do that. What is this method? For the sake of interest, I took one of the latest decisions of the ECJ, because this is the work still in progress, and this method is still being worked upon. In case 2023-09-0106 on amendments to the animal protection law, our Constitutional Court offers this method. According to TFEU Article 49, the Constitutional Court decides that by deciding on a certain case, we have to take into account EU legislation as far as it can strengthen Latvia as a democratic country and protects fundamental rights according to Constitution's Article 68, asking for harmonization of Latvian legal system with EU law. First, ensure harmony. Second, of course, we have to make sure that this also is in the best interests of Latvia as a democratic country, whether in a specific cases the applied norm corresponds to Article 49 of TFEU depends on specific norms of EU law as well as constitutional norms. In this decision, the court says that first, it will evaluate whether the case corresponds to Article 105 of our Constitution, afterwards Article 1 of the Constitution, and then the contested conformity with Article 49 of TFEU. However, in the judgment, this order is not implemented entirely, and that's why the task is to analyze limitations applying Article 105 of the Constitution as well as Article 49 of TFEU. And also proportionality has to be evaluated. It is important to pay attention that according to the case law, the Constitutional Court stated that one of the best interests of the EU is to ensure well-being and welfare of animals. This task, which is also the tasks prescribed by the EU law, is one of the goals stated by the Constitutional Court. That's why it is also written in the legal system of Latvia. The court establishes several other goals apart from well-being of animals, and the court directly applies for Article 49 of TFEU as well as methodology applied by the case law for evaluation of proportionality. This is indeed applied after indication of the ECJ that our Constitutional Court has to still work on establishing and finding the right proportion for ensuring this proportionality. But the question was whether our Constitutional Court was obliged to turn to ECJ for a preliminary ruling. It can be looked at part second of our Constitution as well as TFEU, which prescribes that our judges have to engage into dialogue between us and ECJ in order to ensure uniform interpretation of the laws establishing their autonomy as well as proportionality and proportional application. In the case Consorzio Italian Management that we also call CJEU, the preliminary ruling asked by Italy was whether, according to Article 267 of TFEU, the uncontestable decisions, namely Supreme Court's decision and Constitutional Court, should first ask for preliminary ruling, the ECJ, even if the questions have been asked by one party after submitting all the documents relevant to the court, or even if the court have turned to the ECJ for preliminary ruling regarding another issue related to the case. And this is another case from this golden fund of the case law. Court asked for a preliminary ruling establishing this mechanism and this dialogue between mechanisms. And the goal is to ensure the application of EU law with uniform application in all member states, thus avoiding different interpretation. But the national courts have rights as well as obligation to turn to ECJ if there might be some other interpretation of respective articles as well as evaluation ultra vires. And in this dialogue, as I just mentioned, national courts participate in strengthening and protection of EU values. This is interesting, very interesting in this consortio case. But those courts whose decisions cannot be appealed have to turn for preliminary ruling. And these courts can be released from this obligation only if that the matter is not relevant to the general ruling, or if the ECJ has already given its interpretation, and 3, if the interpretation is as obvious as there might never occur any substantial doubts. And thus National Court has this liberty of evaluating whether there has to be or not has to be request for preliminary ruling. And the court has to also make sure that the last instant courts of other member states have the same interpretation of the question. That means that the judges have to do a lot of work by communicating with judges from other EU countries. ECJ has explained that by applying this interpretation method, we should make sure that in all 24 official languages the interpretation is the same, but that is not possible. The ECJ has said that you can use the languages that you are familiar with, and this is very, very good explanation. So the national courts can exercise this liberty, saying that they can deal with the question, but there is always a risk that there might be some difficulties arising from interpretation, thus establishing the risk of different case law or application of the case law or interpretation of the case law. Our impetus in the general EU law. These values are strengthened by content through legislative process, also through application of existing legislation. Thus, for example, the case of the Constitutional Court is an advantage for strengthening the case law, hoping that even without preliminary ruling, other countries would have looked at this prohibition of killing fur animals according to Article 49 of TFEU. Another case law, Selevich and others, that is also part of golden case law, similar to Laval Viking lines, as well as Fine Point case. In Selevich decision, ESJ strengthening the principle that strengthening of the rights to use the national language is not an impediment to commercial activities. The national language use protects the diversity principle according to Article 3.3 of TFEU, as well as Fundamental Charters, Article of 22, which respects cultural differences as well as national identity, including protection of national language of the member state. Some last sentence. At the same time, we have not paid so much attention to some comments of the same case, because ECJ said also that in order not to overstep the legitimate purpose of the articles, ECJ says that usage of other languages should be considered in order to promote learning and studying subjects that are related to international cooperation and EU values, as well as culture, ensuring the slogan unified in diversity. But finally, I would like to urge all of us to continue to develop and strengthen the coexistence of our national legislation as well as EU legislation and its dialogue. Thank you.
Thank you, Ms. Ziemele, and thank you for emphasizing it once again that every Latvian national judge is the one protecting the European values. Now I will give the floor to the President of the Supreme Court, Mr. SuprīŠs, about the topic, the principle of judicial independence within the functioning of European Union law. As regards independence of judges and courts within the context of the European Union, I would like to tackle two aspects. First, the common legal space requires very high mutual trust, and it's only possible between courts which are independent and follow uniform standards. Second, one of the dimensions of the judiciary independence, we should strengthen both the judiciary independence and independence of individual judges, because these are the factors on which the mutual trust is based. Speaking about uniform standards and application of uniform standards in courts of various member states, there are no huge problems, even if there are any errors. This is resolved on the level of the European Court of Justice, and practice certifies this, like in the process about trade agency, where we spoke about uniform standards regarding the right to receive a court ruling and to learn arguments behind it. As regards criminal cases, I could refer to the case law of 2016 of the European Court of Justice regarding adoption of arrest decisions, where the European Court of Justice said that the cooperation should be between courts and not state authorities like police and similar. This is what is covered. What I have more concerns is that we have new challenges and new threats at national courts, and unfortunately we do have examples within the European legal space. This was the threat to Polish national courts, which affected the actual application of the principle of mutual recognition. This also allowed to perform examination, verification of independence of the relevant national court. And if there are bases to consider that this lack of independence could have affected litigation in relevant criminal cases, this is seen as grounds for denying recognition also in other cases. And the same applies to transfer of a person following the European arrest order. As regards the other aspect of independence, the institutional aspect of the courts of member states has never been an issue regulated by the European Union law. However, it should be taken into account that this year it's the 25th anniversary since Tampere Agreement defining principles for new dimension of cooperation of courts. The matter of independence of courts is included in Copenhagen criteria, which are verified for every candidate country. A country should prove that courts are stable and that they guarantee democracy. Of course, not only court, but also other state authorities. But today we speak about courts. Of course, this obligation is valid also today. Although in individual cases these matters are reviewed by the European Court of Human Rights, on the agenda of the European institutions, the matter of independence and impartiality of courts has been for a considerable short period of time. Internally, I have a question, and I ask this question to myself. Even if it seems all fine on daily basis on the level of national courts, how well are we protected today against stealing of the rule of courts? Are there mechanisms which could prevent such scenarios from the very beginning? Unfortunately, we cannot be too satisfied. I have to refer to the Polish example again, where this was actually done. Unfortunately, also in Latvia, we have heard some phrases attesting that there are some political forces who might be interested in similar methods. Therefore, we are implementing reforms in Latvia to separate court from executive authorities to take over all the matters relating to the budgets of courts. And we want to achieve that all the systemic issues of courts are not dependent on a chance, namely on which political party is represented by the Minister of Justice. So we want to prevent effect of any political changes. The matter of appointment of judges and judges' career is a separate matter. It's been also included on the agenda of European institutions, and in European countries there are different models of legitimization of judges. In Latvia, judges are approved by the parliament, Saeima. So that's a very direct legitimization. In other countries, judges are appointed by president, assigned by presidents, by councils of justice. And in Landhessen case, the European Court of Justice has stated that if executive powers and legislators are involved in these matters, this does not make them dependent on these authorities per se. But in Latvia, our law provides for a 3-year trial period for judges. So judges are appointed for 3 years, and then there is repeated evaluation and separate vote by the parliament. The idea is not bad, but the second voting should not take place in the parliament. This should be decided by the Council of Justice, because this repeated decision in the parliament creates an impression that some circumstances related to rulings by the judge could affect this decision, and somebody might dislike such rulings. Independence and impartiality of judges is not only secured by the procedure of appointment. Judges, as those applying the European Union law, also need formal working conditions, and this applies also to wages. There are some parallels between the European Court of Justice and the Constitutional Court in Latvia, where matters of wages of judges have been examined, and political authorities tend not to comply with such rulings of courts as regards wages of judges. In Latvia, this was a long-term phenomenon from 2009 up to 2018, when this matter was finally resolved. We needed 2 decisions, 2 rulings of the Constitutional Court. We have a similar situation now in Slovenia, where there was a ruling by the Constitutional Court which was not complied with by the political power. The general consensus today is that judges also have to take into account general saving measures in the country, but this cannot undermine the independence of judges. So that's a matter for particular examination, and there cannot be any theoretical models. In the conclusion, I would like to say that court is an important driving force behind the European integration procedures. Sometimes it's said that courts are too active, but reasonable activity is a side product of independence of courts. And it's quite a logical way how courts resolve matters which cannot be resolved by the other 2 pillars of the state authority, or which they don't want to resolve. For instance, if we look on the level of the EU law, without activities of courts, we would not have the judgment in Costa versus Enel regarding priority of the European Union law. We would not have judgments like gain and loss, which is fundamental for the European Union law. And this list is very long, and the court has always made one step further. However, in order to develop the rights of individuals, this has to be done at some point. We see it also on the national level, when politicians were not able to resolve matters of the same-sex marriage, and this could not be resolved on the national level. This is now being resolved by courts in individual cases. So this is what the law has not resolved. Actually, it attests that without the European courts, both national courts and courts of the European Union, we would not have the European Union like we have today. This process is not simple. The legal system is not simple. It is very complicated for a national judge, because in parallel there are several systems which have to be respected. But who has said that a judge's life will be easy in the 21st century? Everything can be resolved, obstacles can be overcome, both on the managerial level by ensuring the organizational part of the operation of courts, by providing training, and this is how we can achieve the equal level of courts in the European Union, serving as a basis for mutual trust, which the European Union is based on. Of course, if we have the willingness to do it. taking into account that we are lagging behind our schedule and I managed to save 2 minutes, I will say thank you and give the floor to the next speaker. Thank you.
Thank you, Mr. Strupiš. And now I give the floor to Madam Professor Osipova, and she will talk about transformation of the understanding of gender equality in the European Union in the last 20 centuries. Thank you very much, Madam Minister. Dear participants, on the same but in a different manner, after the Second World War, European countries began to unite in order to jointly promote prosperity based on common values. It was precisely the common values underpinning European culture that made it necessary for countries to have a common understanding on what is prosperity, how the prosperity is achieved, as well as that this prosperity can be measured not by greatness of the state, but at the expense of the dignity and well-being of each individual. The historians always say that that depends on cultural heritage, which is based on Jewish morality, also by Greek philosophy, above all Aristotle and Plato. But o tempora o mores, the foundations laid by the antique world for the understanding of human dignity, the private autonomy of the person and the right of equality did not include all members of the societies. Those were male, mainly coming of age, and this understanding dynamically has changed during last centuries, especially during the last 20 years in Europe. Now I would like to talk about equality of gender, which is at the agenda of the EU. The demand for equality for all based on ideas of natural rights and philosophy of enlightenment was already formulated in Europe in the first fundamental catalogues, the French Declaration of Man and Citizen of 1789, which stated all men are born and remain free, equal in the rights. It was a revolutionary requirement that was made in a society of order where there were inequality and some privileges of certain individuals. The issue of women's equality was also rejected. The legalization of women's equality started only at the beginning of the 20th century. Today, more than 100 years have passed. A number of human rights and fundamental rights documents have been adopted, which lay down the requirements for equality and prohibition of discrimination on the basis of sex. But especially since 21st century, which also coincides with Latvia's accession to the EU, increased attention of European Union institutions is focused on the implementation of women's equality in life. In recent decades, particular efforts have been made to ensure that this gender equality is not just on paper. In the Parliament of the EU, there is a special committee implementing women's rights and gender equality. Those are two different notions, that not excluding each other, women's rights and gender equality. The Council of Europe's Committee on Equality between Women and Men also operates. Also, Charter of Fundamental Rights of the European Union and other acts are there. By applying them, the Court of Justice of the European Union contributes to the implementation of gender equality. Namely, the Parliament, Commission, Court of Justice are working to eradicate all forms of discrimination. However, statistics show that domestic violence and women's political participation, including throughout political position and representation of women on boards and science and boards of large companies show that it has not been entirely achieved. Although EU lately has started to apply even a derogation from principle of equality, those special measures, in particular for these 20 years. In particular, a more favorable legal environment is being created promoting equality of women. This asks us to revise the stereotypes, especially in families. Statistics show that women in European countries spend more time caring for children at home, so they have less time for themselves, for self-growth, for education opportunities to build political or business career. One solution introduced by EU, for example, is to strengthen the role of a man as a father in the family, in introducing mechanisms for the involvement of the father in the care and upbringing of children. But we do see that many women fight against that. The radical measure is so-called application of quotas. That might be very simple, but it's not. There is an evil joke actually played out. In 2018, Paris municipality hired proportionally more women than men, according to parity regulation, but this Paris mayor or the council was fined. Furthermore, it is not a question of women being guaranteed seats in the parliament or that the partner will take equal care of a child. Without change in public attitudes, these instruments will not work. That's why EU is carrying out thorough and complex social engineering in order to change those stereotypes on gender values, place in the society, as well as scope of rights of each gender, with the aim of achieving true gender equality. However, the equality which is rooted in the dignity of every person is also private autonomy and freedom of choice, which leads to certain conflict. A part of society uses its freedom to restrict the freedom of another part of society in accordance with its view on the correctness and traditional order of things. But a part of the society actually does not want to obtain this equality. Are we going to force them together? I recently saw a dialogue between Slavoj Žižek and Jordan Peterson, where Peterson's actor said, why are we talking about gender equality in politics and business, but we don't want to introduce that equality for plumbers? Whether this equality manifests in all structures of society, 50-50, or it is the freedom of choice of any person that cannot be restricted based on stereotypes. I believe that the latest, both sexes have to be allowed freedom of choice. At the moment, gender quotas are introduced not only in political and public sector, but also in private sector, namely business. EU Commission stresses that there are many highly qualified women because 60% of current university graduates are women. However, women are still underrepresented in high-level positions. That's why there is a directive on improving the gender balance amongst non-executive directors of companies listed on stock exchange. This directive was passed there and back for 10 years, and it was signed in 2022. Today, special measures are increasingly being used to transform societies into inclusive, free and equal society. But we have to remember that those measures are necessary to defend the rights of marginalized, equally restricted groups. That's why these derogations have to be justified. Special measures against women serving sentence are justified, and that was assessed in 2019 by the Constitutional Court. The verdict was that the specific measures aimed at accelerating the achievement of effective equality between men and women must in no way lead to maintenance of unequal or differential standards. The legislator must periodically examine whether the additional protection of the specific group is still necessary, because over time the situation may change and there may come a time when specific measures taken by the state to protect one group is no longer necessary. If the legislator fails to do so, it may happen that special measures aimed at preventing discrimination might become discriminatory. Not everyone is prepared for gender equality, putting traditional values as an argument above all the threat to the family. It is also mentioned by the resolution of the European Parliament from February 2019 on experience of backlash of women's rights and gender equality. In particular, part of society opposes measures aimed at reassessing outdated and discriminatory gender stereotypes and creating an inclusive society. Even in our language, we have a discriminatory attitude. For example, a nurse or a nun is feminine, but a soldier is masculine. Why have we failed to take this obvious gender equality? I can try to explain this using example of Latvia. In Latvia, women gain political equality by founding the state in 1918. Latvian women have been politically fully fledged for more than 100 years, but in some European countries only for 50 years. We don't have to always learn from old Europe. We in Latvia also have experience that we can pass something to European Union. But political perfection does not ensure civil equality. Above all, the wives exit from her husband's power. What is the point that the woman has rights to vote if the husband can deny her rights to go out of the house? However, Latvia can be proud that even at the time when equality had been achieved in public law, but equally in private law was still being worked on, Latvian women managed to reach positions that were previously denied them. For example, the Baltic states not only had judges women, but also in other high legal posts. But women previously were denied legal education, but they had to obtain those rights. After this, there are also female lawyers in Latvia. But the equality of civil equality of women were granted by Soviet occupying power. But there too, although the jure women were equal, de facto society developed in different ways. The Soviet state introduced quotas, gender quotas, national minority quotas, occupational quotas, thus creating an illusion that the whole society participates in the administration of the state. that at the same time forced people to significantly change intersex relationships. This contributed to inequality in different parts and USSR. This was influenced by local traditions, namely atheists, Catholics, Protestants, and others. What I wanted to say with this historic argumentation, that the determination of gender equality de jure does not automatically lead to equality in life, equality at home, family, and it is also looked at by the courts. Totalitarian state did not manage to achieve true gender equality even through 50 to 70 years. In Russia, quite patriarchal views on the family and the place of women in the society still prevail. Gender quotas and other instruments do have their downsides, especially now when private autonomy develops. A person is entitled to change its sex. In one case, if a man becomes a woman, he gains some privileges. But if a woman chooses to become a man, she loses this support. Something is legally wrong. The solution is true gender equality. Namely, gender does not play the role in person's self-determination and integration in the society. To achieve that, EU has put a huge amount of work into achieving that, but no less work is yet to be done, because in different EU countries, even within the same country, different groups of society have fundamentally different views on what gender equality is. And on many issues, those are the courts who deal with this social engineering issue and ensure true implementation of gender equality. Thank you very much for your attention.
Thank you very much to all honorable panelists. And today our panel has covered many important topics related to the period of 20 years since Latvia has been a full-fledged member state of the EU, and also matters related to protection of other EU core values. We looked at challenges after joining the EU. We looked at common values, challenges of national codes before joining and in the first years after joining. Also implementation of the principle of independence of courts, and finally touched upon the issues of gender equality. In the conclusion, I would like to emphasize that the EU values, these are cornerstone values on which our judiciary system is based and our society is based. These values are not only national, these are deeply rooted in our membership of the European Union and the Council of Europe. Independence, impartiality, and gender equality, this is what helps us move ahead and to develop into the society we want to be. This is a state which we want to have. This is a state trusted by our people and by our allies. We are all together, and we all together need to work on implementation of these values and protection of these values. I see several tasks to all authorities, also to judiciary, because also the judiciary has to find the right response to using artificial intelligence and preventing relevant risks. Also, the judiciary system will play a decisive role in resolving disputes regarding the effect of climate change and compliance of business to sustainability requirements. I also think about the European Directive of Corporate Sustainability. And as our guest from Ukraine said, the military threat caused by Russia and the Russian military aggression in Russia and war crimes, this is still an important challenge for a rule-based order in the world. Judges need to be knowledgeable. They have to be alert in protecting the national safety. They have to follow the principles of loyalty, and they need courage, and they need to be alert to protect sustainability in these challenging times, because the modern justice requires assuming responsibility and not hiding behind any laws. Judiciary has to be alive, and justice has to be alive and respond to important modern challenges. And they have to be able, it has to be able to predict any possible consequences. They have to, courts have to follow the principles of law and apply these principles. This is how we are going to secure good cooperation between all the involved players on the national and international level. We've been speaking today about the possibilities of national courts to submit applications to the Constitutional Court to ask preliminary questions to the EU Court of Justice. And this also strengthens our common values and contribution by the judiciary to the work of the Ministry of Justice. I'm very thankful for this, so we can develop our law even more. Thank you to everybody who participated in this panel. Thank you for listening to us. And thank you for thinking along. I'm sure that the rule of law and justice is what's gonna win in these times, as it was wished by our Ukrainian colleague. Thank you, everybody. Now we will have a coffee break in the next room, and we will resume in 15 minutes for the next panel. Thank you.
Labdien,
Good afternoon, dear colleagues. So we can continue. Honorable judges, researchers, the one thinking about Europe and the one thinking about law. The preceding panel, led by our Minister of Justice, put a lot of responsibility upon us. We have to be exciting, and we have to be very accurate in time, because the responsibility that lays with us. Lunch break follows after our panel, and the right to lunch could be one of the absolute fundamental rights, which we as judges should not be able to verify, but we also have to provide this for ourselves and for others. Therefore, we will try to work according to the rules of procedure of today, and I'm glad today to be the moderator for the discussion about the European Union and national identity. We have 4 esteemed panelists. I will present each of them when I give the floor to them. We will start with a colleague from the Court of Justice of the European Union, the judge, Dr. Mr. Irmantas Jarukaitis. He has worked as a judge also in the Lithuanian Supreme Administrative Court. He has been a professor in the Vilnius University, and his doctoral thesis was about the constitutional basis for ensuring membership of Lithuania in the European Union. So the floor is yours, and your topic, the search for equilibrium between the unity and national identity in the case law of the Court of Justice of European Union.
Dear President of the Supreme Court of Latvia, of Ukraine, Madam Minister of Justice, dear colleagues, dear friends. It's really my honor, privilege, and really pleasure to share with you this magnificent moment, because at least to me, and I think to everybody of us, this anniversary is probably the biggest geopolitical victory of 20th and 21st century for our countries. Today we heard a lot about values, and this membership is really about values. And when I was asked to make a presentation, I thought that one of the topics which would be of interest to all of us is basically the nature of the union that we are part from 2004. So that's why I chose the subject about I don't know how to start. It doesn't. Ah, yeah, it works. I don't. Ah, yeah. Oh, great. So the topic of my presentation is the search of equilibrium between unity and diversity in the European Union. And basically, first of all, I would like to speak about this deeper philosophical nature of the integration process. Then to speak a bit about this unity spring within the Union. Then about the diversity. Then about the search of equilibrium between those two values. And then the last part would be, so what is actually the role of national judge in that search of this equilibrium? And of course, I have to be very strict with time, because I was warned that I could impinge on one of the fundamental rights, so I'll try to be as brief as possible. So, okay. Actually, the first question that arises in the context of the European integration process actually is, what are the aims of that process? And if we look back 200 years ago, Immanuel Kant, in one of his works, Towards Eternal Peace, he made a statement that peace is not a natural state of affairs between relations of states. And actually for a long time, like, I don't know, 40, 50 years after the integration process started, there were many discussions that maybe peace already became a natural state in relations, at least between states of Europe. But what we see now in Ukraine, it shows that it's not the case. It shows that still this essential proposition is valid, that peace has to be established, that, as Schuman said, you need creative efforts to do that. So that's one aspect. The other aspect is that basically what kind of integration and what kind of union we want to achieve. And here I think, at least for me, one of the fundamental ideas comes from, of course he was not the first, but basically probably he articulated it the best, is from Joseph Weiler, who in one of his articles around 30 years ago said that basically when we look at our history, at history of our civilization, basically there are three main strategies of how to deal with persons of other identity, of groups of persons of other identity. First is simply to destroy. I don't like that you are different, and I simply destroy you. And of course we know examples of that. Second strategy, as he said, is more civilized. basically saying, well, you know, you have different identity, but you can switch to mine. And in that case, there would be no problem. There would be no diversity, no tensions. And what we see now in Ukraine is exactly that. All Russia is saying, you simply have to stop being Ukrainians. Let's be Russians. There would be no problem. And of course, in that sense, it's not only ethnic, but it's also related to values. What kind of values this different identity carries on. And the third strategy that is chosen by the European Union, by the integration process, is a strategy where you recognize different identities, cultural, linguistical, even political, and try to live with those separate identities. The biggest problem so far is that, again, another quote from Robert Kagan, American political scientist. He wrote in 2003 that, on the one hand, Europeans, by their creative efforts, they were able to create a paradise of Kant. But the biggest problem is that the rest of the world is still the world of Hobbes. And basically, you may not escape that. You have further to promote this quest for integration in order to sustain it, in order to make it viable. And basically, again, if to look here, I mentioned as well, as you see in my slides, basically the perspective of national constitutional law. If you look, for example, at the Constitution of the Republic of Lithuania and jurisprudence of the Constitutional Court of Lithuania, basically the membership in the Europe is put in geopolitical perspective. It's not about economy, not only about economy, first of all, it's about values and simple survival, because we, basically all Baltic states happen to live on this geopolitical fracture. So, first of all, a bit about unity. So, basically, of course, if you look from the philosophical perspective, of course, there should be some unity, some common ground in order to live together. If there would be no minimal basis of unity, of course, such coexistence could not exist. And if we look at dynamics of the process of integration, at the beginning, of course, it was only economic integration, although we understand that the goal always was political, it was political integration. And of course, at the beginning, when it was only, or more or less, economic integration, this issue of values, of fundamental values, was less relevant, because, of course, money does not have boundaries, it's more or less the same. But when we look further, basically with the Maastricht Treaty, when the competences of the European Union started to expand, and today, for example, Professor LENAERTS gave different examples, basically EU law touches more or less every important part of human subsistence. Of course, to imagine that there should be or could be no common value unity is not possible. And because of that, if you look at the Lisbon Treaty, at least for me, the Lisbon Treaty is really the turning point, because from that on, the European Union presents itself as a union of values. So Article 2 was already mentioned several times. The Charter of Fundamental Rights became obligatory, and as we spoke already, basically Article 49 of the treaty very clearly establishes that basically in order to accede to the European Union, of course, you have to respect those fundamental values as established in EU primary law. And what is very important, later on I'll come back to that, basically when we look at jurisprudence of the Court of Justice, the Court of Justice, when it deals with those different issues of national diversity, first of all, always establishes a systemic compatibility of those values at different levels, so at national level and also at the EU level. And only after that it starts dealing with to what extent this diversity should be recognized or not recognized. And again, for example, from the point of view of unity, again, if you look at the constitutional act of the membership of Lithuania, one of the basic prerequisites which is mentioned in the preamble is that basically the European Union respects those fundamental rights and liberties as respected and protected by the Constitution of Lithuania. So there is a systemic compatibility at the value level. And until recently, actually this aspect of unity was more or less theoretical, in a sense that there was not that much of jurisprudence of the European Court of Justice, but in 2022, in conditionality regulation judgments, two judgments of the full court, basically the court had the opportunity to deal with it. And the context was very interesting in a sense that from the first glance those two cases were very mundane cases. The question was whether the legislator of the European Union could adopt conditionality regulation on the basis of Article 322 of the TFEU. So in essence, whether these are financial rules. So very mundane, very technical issue. But where was the problem? The problem was, at least one of the problems was that one of the representatives of one of the states that initiated proceedings before the court said openly in a court hearing that for them there is no principle of rule of law as a legal principle, that it's only more or less a political statement. And here we started speaking about Article 2, whether it's really true. And as you see from the passages cited, basically the court rejected that approach, saying that no, Article 2 is not only political statements. These are fundamental values which are common, so they are not imposed by the EU, they are common to all member states. And then they are translated in legal principles, and those legal principles are enforceable as legal principles, as legal standards before EU and national courts. So, although the court clearly recognized basically that, of course, there are separate national identities, that basically the EU, as already we spoke today, has no substantial or material competence to organize, for example, national judiciary. As regards the result, the respect for the rule of law, the respect, for example, in other cases that were also mentioned today, Republica and all the others, the result to ensure independence of national judiciary, this is what stems from Article 2 and from other articles of the treaties. Now, the other aspect, diversity. As I mentioned, at least for me, it's a fundamental aspect in two senses. After the Lisbon, now there is this Article 4, Paragraph 2 of the TEU. And basically, of course, there is very big discussion in academic doctrine, what is basically the content, what were the intentions, what is the impact on interpretation of EU primary law, and we'll come back to that later. But at least to me, this article basically has two functions. So one, to recognize once more that statehood is a natural ingredient of that integration process, that the European Union is based on states, and it means that their political identity is recognized, and then of course cultural, linguistical, and the rest. And then of course in itself as a rule that requires to protect at least and to respect at least to some extent those national identities. So again, it's interesting that there is some coincidence. If we look back to jurisprudence of the Court of Justice, it started long before Article 4 was introduced, and one of the first cases, it's 89, is Gröner. Again, it's about linguistic protection in Ireland. And before Lisbon, the court had quite a lot of opportunities to develop this idea of national identity, which first was mentioned by the Treaty of Maastricht in Article F, and then was expanded by the Lisbon Treaty in 2009. And for me, I think that the basic idea was very clearly conveyed in Omega Spielhallen in 2003 or 4, if I remember correctly, where basically there was a very simple question. If a company who legally imported certain game equipment from the UK, yes, so we speak about free movement of goods, whether Germany could prohibit that game because it imitates killing of a person, although it's legal in UK. So on the one hand, and basically in many of those cases, we'll speak later, it's about internal market, about fundamental internal market freedoms. The question is very simple. In UK it's allowed, in Germany not. And German argument was very simple. It's our historical heritage. It's because of the Nazi period. We think that such imitation simply undermines human dignity. So how could you compare? Could you say that EU law requires maybe simple to inform customers that it's not good? Could it probably say that, you know, maybe it's allowed from the age of 21? Should it require some transitional periods, saying that, you know, or you could play once a week? Yeah? It's all about proportionality. And the response of the court is no. Well, the response is very simple. There could be different perceptions because of different historical contexts in different states, and EU should recognize that. And of course, because of that, basically, a member state has wide discretion. And again, coming back to what I said about those functions, again, if we look at the Constitution of Lithuania, Constitutional Act, the second basic precondition, which is clearly mentioned, is that Lithuania acceded to EU on the premise that EU respects national identities of the member states. That's essential basic precondition for that. So what is the impact from, if we look at jurisprudence so far, what is the impact of Article 4 for the rest of EU law? And at least for me, I think that there are at least 3 ways in which Article 4 influences the result of interpretation of EU law. So first of all, there could be an influence on the definition of the scope of EU law or scope of particular piece of EU legislation. One of the cases I mentioned, Dory, basically German case, again, decision which was rendered before the Lisbon Treaty. The question was very simple, whether German constitution, which establishes obligatory military service only to men but not women, the subject that we spoke today, is is against EU law because there is a directive on equality of treatment between men and women in labor relations. And the problem was that a year before, in Tanya Krail case, the court said that in the context of professionally military service, this directive applies. So here there was a question, we speak about obligatory military service, whether this directive is applicable or not, and as you see from the response of the court says no. These are the basic choices of a state, how to organize defense system, national military system. It's up to them to decide how to organize it. In similar way, in 2021, Slovenian case, Ministerstvo za obrambu, there was a question to what extent the directive on working time is applicable to professional soldiers. And again, as you see, the court basically refined a bit its position, saying that in general, because it's a harmonized area, it's not excluded, but still, in certain situations, this directive, because of the existence of Article 4, these relations are not included in a scope of application of that directive. Second aspect, the most widespread, I would say, is giving member states a wide margin of appreciation. Why it's important? It's important because in the context, again, of internal market freedoms, usually the court would say that it's a strict proportionality test. Here the approach is different, and of course I couldn't resist temptation to mention the case, Latvian case that was already mentioned today. As you see, basically again what the court does, it says, well, yes, I understand, and as you see from the judgment, and I understand that Latvian Constitutional Court understood as well very well the context, member state has a wide margin of appreciation. And the last, I'll leave 5 other slides for next conference. Basically, I'll have to skip that as well. The third aspect, basically, as we see from our recent jurisprudence, Article 4 may have influence on the content of EU law, of interpretation of EU law. And at least for me, very good example is judgment of 2020, La Quadrature du Net, where basically directive says that member states may establish certain rules, derogating from the principle of secrecy of communications in order to secure 4 enumerated goals. And what the court does, he said, well, although directive is silent on the hierarchy of those aims, for us, for the court, national security is superior to other aims, and because of that, it's more important, because it's national security, it's in the Article 4, and because of that, again, member states may impose stricter rules. So basically, the consequence of that different hierarchization is, again, the latitude of the member states to retain traffic and location data. So just 30 seconds to what is the role of national courts, because we speak about responsibility of all of us. Basically, all cases that I mentioned, except one, conditionality judgment, these are cases coming from national courts. So basically, all those problems, they were identified by national courts. They were conveyed to the CJEU with the arguments. And basically, that's how judicial this court functions. It's up to you as national judges, those who apply EU law, to identify, to specify, to provide for arguments why in Latvia it's different, why history of Latvia, Lithuania and other states are different, why those rules persist. For example, very good example, signed Wittgenstein case, where Austria said, well, you know, we have a prohibition of nobility titles. Why? Because we had an empire. And then one day we decided that we want to establish a principle of equality of all men. So nobility titles, although in other member states may be allowed, not in Austria. So, congratulations once more with the 20th anniversary, and I wish you all the best.
Paldies tiesnesim.
Thank you to the Judge Aigars for his presentation and also for keeping up with the time schedule. And we will remember your promise regarding your presentation at the next conference. This was a great insight, also touching upon philosophical aspects. We will celebrate the 300th anniversary of Kant this year, and I think it shows that also at this part of Europe we have moved ahead and we should strengthen these ideals. We will continue now, and the next presentation will be by the judge of Slovak the Supreme Court, Mr. Holic. He's been working as a judge on all court levels, so he has a diverse experience and application of the EU rights as well. He specializes in civil law, and his topic is related to challenges for the judiciary after EU accession and their solutions over time. Mr. Holic, you have your time now.
Dear ladies and gentlemen, dear colleagues, the Slovak Republic emerged as an independent state following the peaceful dissolution of Czechoslovakia in 1993. After gaining independence in velvet divorce, Slovakia embarked on a path of political and economic transformation, seeking closer integration with Euro-Atlantic institutions, including the EU and NATO. Slovak judiciary was formed in the background of numerous social changes and challenges, which naturally had a significant impact on the development of the Supreme Court of the Slovak Republic. The Supreme Court of the Slovak Republic also celebrated its 30th anniversary last year as a reminder of the observance of democratic values on which the independent Slovak Republic was founded in January 1993. The President of the Supreme Court of the Slovak Republic, Mr. Jānis, highlighted on this occasion that the entry of the Slovak Republic into the European Union to be the most fundamental moment in the 30-year history with which even the Supreme Court signed up to European values, the importance of which is essential to be perceived even today. The Supreme Court is currently a stable part of international structures within which it has the opportunity to conduct international dialogue and be inspired by partners who promote the idea of a modern judiciary. The leadership of the Supreme Court considers the idea of a modern judiciary and the principle of open justice, justice that has the trust of citizens, to be the pillars of the rule of law. This year we commemorate also the 20th anniversary of EU accession. Access of the Slovak Republic to the European Union marked a significant milestone in the country's history and its integration into the European community. The Slovak Republic has been a member state of the European Union since 1st of May 2004. The accession process involved extensive negotiations with the EU on various policy areas, including the economy, democracy, rule of law, and the adoption of EU laws and regulations, the acquis communautaire. One of the fundamental values of the EU, also referred as the part of the constitutional identity of the EU, is the principle of the rule of law. However, even if the EU imposes the obligation to respect the rule of law, providing a comprehensive list of minimum requirements to be met in any circumstances, seems to be challenging. Thus, the EU lacks clarify when defining the rule of law concept. The key elements include legal certainty, equality before the law, respect for fundamental rights, effective legal remedies, as well as an independent judiciary. Essential to uphold the rule of law is to ensure that laws are interpreted and applied impartially. If we consider that the organization of the judiciary is the diverse field of various national systems, which has traditionally not been covered by the acquis communautaire, the concept of the rule of law seems to be the most challenging, especially for the judiciary. CJEU's jurisprudence refers to the independence of national judges as a necessary facet of the rule of law as understood under Article 2 TEU. Considering the data of the European Commission report from January 2023, 53% of EU citizens rate the justice system in their country in terms of independence of courts and judges as good, while 36% say it is fairly or very bad. Maintaining judicial independence is crucial for upholding the rule of law and ensuring fair and impartial justice. However, there are several challenges that can threaten judicial independence, including political interference, lack of institutional autonomy, pressure from specific interest groups, etc. Addressing these challenges requires concerted efforts to strengthen legal protection for judicial independence, promote transparency and accountability in appointment of judges and decision-making process, enhance judicial training and professionalism, as well as foster a culture of respect for the rule of law and judicial independence. Additionally, international cooperation and support can play a crucial role in helping countries address systematic challenges to judicial independence. In Slovak Republic, most of the respondents considered interference or pressure from government and politicians as the most significant factor challenging the judicial independence. There have been concerns about perceived political interference in the judiciary. This has raised questions about the judiciary's ability to operate independently from the executive and legislative branches of government. In context of recent events, when government officials verbally attacked the judges of the Supreme Court and the Constitutional Court, the Judicial Council of the Slovak Republic strongly appealed on the executive and legislative power, as well as other public officials, to respect the independence as one of the pillars of the rule of law when making public statements about the court decisions and/or judges. The Judicial Council considers it unacceptable if the representatives of executive or legislative power appeal publicly for disciplinary or criminal prosecution of judges and/or make public statements violating the principle of presumption of innocence in relationship to disciplinary or criminal proceedings or sanction of judges. Respecting the right to professional and factual criticism, which must not have form of the Judicial Council highlighted the need for criticism within the limits of elementary decency, which must not have form of intimidation, coercion, or other form of influencing the decision-making activities of judges. In the Slovak Republic, like in many countries, judicial independence faces several challenges. Public trust in the judiciary in Slovakia has been relatively low, with surveys indicating perception of corruption and inefficiency within the judicial system. The Slovak judicial system has faced challenges related to case backlogs, delays in court proceedings, and inefficiency in the administration of justice. To maintain the judicial independence, also ensuring high ethical standards and professionalism among judges is crucial. Slovakia's judiciary may, like many other member states, faces resource constraints, including inadequate funding, staffing shortages, and limited infrastructure. Addressing these challenges requires sustained efforts to uphold the rule of law, promote transparency and accountability in the judicial system, and ensure meaningful judicial reform in line with international standards and best practices. And it also requires constructive dialogue. Although the challenges for the judiciary in the EU may vary, they often include ensuring the consistency of legal interpretation across member states. In order to ensure that the specific characteristics and the autonomy of the EU legal order are preserved, the treaties have established a judicial system intended to ensure consistency and uniformity in the interpretation of EU law. In particular, such judicial system has as its keystone the preliminary ruling procedure provided for in Article 267 TFEU. It enables national judges to refer to the Court of Justice of the European Union questions regarding the validity and interpretation of EU law, and therefore to set up a dialogue between the Court of Justice and the courts and tribunals of the member states, so that consistency and uniformity in the interpretation of EU law is ensured. From the countries accessed in 2004, the Slovak Republic was in 2006 the fourth member state to refer the preliminary question to CJEU. Since its accession to the EU, the Slovak Republic has referred a total of 86 preliminary questions. Even though they focused on different areas of the Union law, it's possible to identify several tendencies: protection of the consumer's rights, interpretation of the secondary law in the context of the Charter of Fundamental Rights of the European Union, and increasing tendency in preliminary question in criminal matters. National courts have the widest discretion in referring questions to the CJEU involving interpretation of relevant provisions of EU law, that discretion being replaced by an obligation for courts of final instance. As the jurisprudence of the CJEU refers, a rule of national law cannot prevent a national court, where appropriate, from using that discretion or complying with that obligation. Court of final instance not complying with such obligation violates the fundamental right of the parties to judicial protection and to a legal judge, or their right to a fair trial. In this context, the importance of interpreting national law in accordance with EU law cannot be overlooked. The requirement for national law to be interpreted in conformity with community law permits the national court, for the matters within its jurisdiction, to ensure the full effectiveness of community law when it determines the dispute before it. This principle also requires the national court to consider national law as a whole in order to assess to what extent it may be applied, so as not to produce a result contrary to that sought by the directive. A national court is required to consider the whole body of rules of national law and to interpret them, so far as possible, in the light of the wording and purpose of the directive, in order to achieve an outcome consistent with the objective pursued by a directive. However, the limit of this obligation is the prohibition of such an interpretation to the application of national law or in the light of union law, which would be contra legem. In its jurisprudence, the Constitutional Court of the Slovak Republic clarified as jurisprudential excess when the referring court interprets the operative part of the judgment formulated by the CJEU in the preliminary ruling procedure in isolation when examining the case, not considering the context of the entire reasoning of the decision of the CJEU on the preliminary ruling. In order to conduct the proper dialogue with the CJEU, the national judges should always mind their obligation to interpret the law in the context of EU law. Obligation to properly interpret EU legislation therefore remains the challenge for the judiciary even after 20 years of the access of the Slovak Republic to EU. Thank you for your attention.
Thank you to the judge, Mr. Holic, for this insight into Slovak approach in application of the EU law provision. And I think perspective of the two speakers showed that the legal method is very important. How we judges work with a legal provision, how we see the link between the national provision and the EU legal provision. So that's the answer to efficiency. And another aspect which I heard is that we should not be cautious, we should not be shy to admit that the principle of the rule of law is one of the key elements in our identity. So neither Europe as such nor our countries will never be states as we wish to see without these principles. Let's continue with the insight in the practice of various countries, and I'm happy to see that we are going to speak about Latvia now. My colleague in the Supreme Court, the Senator of the Supreme Court, Professor of Stradiņš University, Sandra Kaja, she specializes in criminal law and criminal procedure. And we will see that the EU law is everywhere. We cannot imagine any field of law without this. And her presentation about the court's role in preserving national identity. So the floor is yours.
Thank you very much, Honorable Madam Minister, Honorable presidents, judges, participants. I am indeed very honored to speak in front of you, and I would like to start with an insight into the past. In order to strengthen our independence, stability and security, integration into EU processes as basics of national foreign policy was valid since already Latvia's restoration of Latvia's independence in 1991. In 2003, September 20, national referendum was held in Latvia on joining EU, and for or in favor, we had almost 67% of all the eligible voters. On the same year, October 10, Saeima ratified Treaty of Association of Latvia to the EU. And in 2004, 1st of May, Latvia became a member of EU. Thus, a little over 20 years ago, Latvia and 9 other countries, Estonia, Lithuania, Czech Republic, Cyprus, Hungary, Malta, Poland, Slovakia, Slovenia, and Hungary became members of single European judicial area, impacted each country's national legal system, national courts, and in particular, Supreme Courts of the member states. Besides, apart from the interpretation, that has authoritative power, with some exceptions. It has separate status, but interpretation of EU is mandatory for all the national courts. An important point to remember is also that in context of EU law, the Supreme Court is in fact no longer the last instance from the point of view that national law must be interpreted according to EU law. And as you know, exclusive right of interpretation of EU law lies with the Court of Justice of the European Union. Thus, judge of the National Court, and in particular the judge of National Supreme Court, is obliged in every case to verify whether the national applicable law not only corresponds to the Constitution of Latvia, but also to the law of EU. But there is no doubt that the country does not lose its national identity by joining EU. In addition, the EU has legal obligation to respect national identities of the member states. The Treaty of Lisbon contains a clause stipulating that the Union must respect the national identities of its member states. Here I could continue debates on what is national identity and whether this term is identical to constitutional identity that we have had very broad discussions, especially in Germany, as we've heard today. But I will not turn to this more today, but I will speak about two values that has been mentioned in the Constitution of Latvia, in the preambular. This preambular states that Latvia's identity in European culture state is formed by Latvian and Livonian traditions, Latvian way of life, Latvian language, universal human and Christian values, trust to Latvia, Latvian language as only state language, freedom, equality, solidarity, justice, honesty, work ethics, and family are the foundations of a cohesive society. Taking into account this preambular of the Constitution of Latvia, first I would like to talk about the language of Latvian that has been indicated as one of the traces or prominent nations of our identities. It has also been stressed by our former President Egils Levits, who said that there is an obligation to guarantee the existence of Latvian language and culture and its development throughout centuries as a basis of our country, as well as long-term existence of it that should not be lost or forgotten or proclaimed to be unimportant. The Latvian language and existence of the culture of Latvia ensures the keeping and strengthening of Latvian identity. And indeed, from this as well, the resistance and remaining of our nation, culture and language is in question. The essence of that is to ensure this identity in life by putting an obligation on the state of Latvia not to do anything that could weaken our identity, but a positive obligation to, in contrary, strengthen it. And here I cannot escape from mentioning a case law from September 2022, Boris Cilevich and others versus Saima, or Parliament of the Republic of Latvia. This was already mentioned by both Madam Ziemele as well as our colleague from Lithuania and the President. And I would like to speak about two moments why this case law is interesting. First of all, it mentions the clause that was mentioned already, namely that national identity should be respected of national countries. Also, this case law demonstrates that Constitutional Court involved or got involved into asking preliminary ruling for preliminary ruling in order to allow to use Latvian language as I will remind you about the essence of this question. It was initiated after suggestion of 20 parliamentarians after there was a law passed that higher education could only be obtained in Latvian language, except for several courses. And it was opposed that private schools, private universities can have studies in whatever language they want, especially mentioning or thinking about Russian language. And EU case law demonstrated that the national languages should be promoted, and education is a very important part of official area of language usage, can thus be restricted, and it can be prescribed that these programs should be in national languages with specific derogations that other EU languages can be used. This case strengthens our position and is an indeed very good example how by preliminary ruling national identity can be strengthened. The second question that I would like to talk about is justice. Justice, looking at it from the context of selection of judges. The supreme principle of the rule of law is to ensure supremacy of rights over democratic, political, and contentious orientation of law towards implementation of justice. It imposes an obligation to organize the institutional system in such a way that these goals can be achieved. That means that institutional system of the state is based on the principle of separation of state power, dividing state power into legislative, executive and judicial power. The judge, as a representative of this judiciary power, is the enforcer of justice. And it depends on that person alone whether the justice will be achieved. Charles Louis Montesquieu, in his work, wrote that the national judge is just a mouth to pronounce the word of law, but it has been a long way since he said that. Nowadays, the judge not only forces, comes up with a judgment, but ensures also the functioning of the rule of law, as well as protecting the national identity. And therefore, there should be an order how a judge is appointed. And it depends on the selection process, how what the quality of judges' work will be, as indicated by an international criminal courts judge, Sanji Monankwe, said that the successful judiciary is one where members are appointed after a rigorous process, assessing both legal qualifications and integrity of the candidate. There are several requirements in different countries, but with an aim to appoint the best of the best in the position of the judge. A judiciary that is not created without taking into account these preconditions lacks legitimacy to come up with just rulings. ECJ has mentioned that in a case law, Gušmundur Andri Astrašson versus Iceland. This is an interesting case because apart from application to European Court of Human Rights, a person turned who was criminally accused. He said that one of the judges who looked at his case in the appeal court was not appointed according to the specific procedure and the law. And the situation was the following, that the Minister of Justice put forward such candidates for the appeal judges candidate, the candidates that were not recognized as best candidates by the Council of Judges. And what were the findings in this case of Iceland, where breaches of Article 6 of the Convention were found? In order for a court to be recognized as such, it not only should be able to be neutral and objective and impartial, its members, the judges, should be selected in a specific procedure, selecting the more qualified candidates, both in technical abilities as well as moral maturity. And the higher the judicial instance, the higher the requirements. The appointment as a judge of a person who fails to meet the relevant criteria may violate a judicial criterion established by the law. In the EU, there is no uniform procedure how to select judges. Also, the selection board or appointment board is different, and approach is different. Mr. STRUPIŠS already mentioned Land-Hessen case, which is very interesting due to the fact that the selection of judges or the selection board's impartiality was looked upon. Because in this case, the part of selection board was appointed by the legislative power. Speaking about Latvia, we could be proud that we are a step ahead, namely that the candidate selection is done by judges themselves. For example, regional as well as district court judge selection, the council creates a commission or a committee where 3 senators, 3 district court judges, and 3 regional or city court judges are elected. But persons who are already judges and who would like to be candidates in a higher instance court, self-regulation of judges, is observed. Not only that the judge already has to be a judge, but it also has to undergo a special college exam or an opinion has to be passed about the sufficiency of knowledge of such a candidate. And finally, I would like to point out that successful work of justice system is closely linked with the selection of judges, and during these processes the judges who are involved have significant role for strengthening the national identity. That's why they have to select the best candidates, because their professional work will impact the future decisions. They have to be impartial, objective. They have to be able to learn, to develop, to be able to work in self-governance of the institutions as well as their professional work will be the one impacting Latvia as democratic and independent and law-abiding country. Thank you.
Thank you, Ms. Kai. We continued about the importance of the lawful country, focusing on the role of the judiciary. We can see that professional and fair judiciary is one of the manifestations of our identity. Now we have our concluding presentation in our second panel. It will be by the judge of the Superior Courts of Malta and senior guest lecturer of the University of Malta, Dr. Aaron Bogeja. Dialogue and adaptation, dilemma or panacea. I would like to emphasize that our presenter has prepared a presentation with consisting of 2004 words, and it's not by chance. It resembles the year when all of us joined the European Union.
Okay, dulcis in fundo. Honorable Minister, distinguished participants, colleagues, it is my pleasure and honor, of course, to address you today on the topic of the European Union and national identity under the broader heading of the values of the European Union, the responsibility of the national judge. For many of you, what I shall be saying may sound rather obvious. Yet sometimes, especially in difficult times, stating the obvious does not come as so obvious. When people resign to take things for granted, stating the obvious may also become an eye-opener, a reminder of where we're coming from. As judges, normally we love definitions. So let's start with definitions. National identity may be defined as a social construct of how a group of people nurture a sense of belonging to a nation by reference to a set of shared markers they consider meaningful and representative of their own intimate self and collective being, reflected through their ethnicity, geographical area, culture, common traditions, religious belief, language, symbols, colors, music, food, and other common factors that they feel that they define who they are. And in point of fact, they distinguish them from others. Customs and laws, too, are part of the strongest markers of national identity, which move with it in a circular dynamic. While laws reflect the core values and beliefs of a nation hewn through space and time, in turn, laws ingrain, reinforce, and define national identity and unity through the creation of a sense of shared purpose and belonging to a common reality politically reflected in national sovereignty and independence. Oopsie daisies. So, since its inception, European Union law has been developing amidst the complex landscape created by deeply rooted, diverse and strong European national identities, sometimes serving as the mover, while in others acting as the victim of the tension created by the slow and gradual development of an autonomous European identity sculpted by it, which European identity in turn, and in its own right, generates other laws that then affect national identities to their core. This process leads to dilemmas for member states due to its impact on the diverse national identities, including loss of national legislative autonomy due to the overriding principle of primacy of EU law over national law, social and cultural impacts arising from the lack of alignment between the policies stemming from EU law and the cultural norms of member states, economic adjustments that member states would be forced to make to comply with EU laws, causing strains on the local economies, industries, and traditional practices, added administrative burdens, especially in the case of the smaller EU member states, where the heavy administrative burden diverts the limited national resources from other national priorities, political influence that may challenge national identities, leading to resistance by member states who may resort to protectionist policies, which in turn lead to other legal and judicial challenges when national courts apply EU laws that could conflict with established national customs, laws, and traditions, which in turn bring public perception issues, leading to European integration becoming seen as an encroachment on national identity, if not also undermining the legal sovereignty of that nation state, raising fears sometimes of territorial cohesion, where, especially in the case of small island member states, territorial cohesion challenges require them to balance the benefits of European Union membership with the preservation of their unique geographical and cultural characteristics. So, it is easy to see how these impacts create tensions and dilemmas for member states who must abide by the treaty obligations on the one hand, and the sense of national identity of the citizens on the other. Balancing these tensions and dilemmas is not easy, especially in a scenario where time-tested national identities are still very strong when compared to the emerging autonomous European Union identity. These impacts, tensions, and dilemmas generate a sense of alienation between European Union citizens and the Union, to the extent that many question whether going through this process is still worth it at the end of the day. Well, the British settled this question for good. But for us who choose to remain, every so often we need to make a reality check, resolve not to take things for granted, and remember where we're coming from and what keeps us here. In 1941, during the height of the Second World War, while confined on the small remote island of Ventotene, Altiero Spinelli and Ernesto Rossi drew the Manifesto di Ventotene, later published in 1944 by Eugenio Colorni as a manual for a free and united Europe. From the ashes of those tragic moments, Robert Schuman, Konrad Adenauer, Alcide de Gasperi, and others laid the foundations of a new Europe, with their own version of turning swords into plowshares, using the tactics of dialogue and adaptation. Well, today we judges are an integral part of that process, from the standpoint of the interpretation and implementation of national and European law. Just like our political forefathers, we, the judicial progeny, need to focus on dialogue and adaptation as a means in the pursuit of the European project. Dialogue entails conversation, exchange, and understanding, but not imposition. Adaptation requires organisms to change in order to survive in changing environmental conditions. And while so doing, the organisms change their environment too. A circular dynamic on a micro and macro level. So, alongside the treaties and following European Union law, the Court of Justice of the European Union case law shapes European Union polity, politics, policies, core values, and thus influences the identity of the Union. Dialogue between national judges and the Court of Justice of the European Union and the process of adaptation that follows serves to manage some of these impacts of European Union law on national identities. The ensuing tensions arising from the Court of Justice case law are mainly cushioned by the balancing acts which that course tries to achieve between European Union laws and national identities by underlining the spirit of Article 4 sub Article 2 of the Treaty on the European Union on the one hand, while safeguarding national competencies through subsidiarity and proportionality principles on the other. But this balance cannot be struck always. Primacy of EU law is one such case. When primacy of European Union law is at stake, the Court of Justice requires member states to reconsider some of the age-old customs or traditions by stressing that claims based on national identity cannot put that primacy into question. So, for example, take the case number 391.09, that is the Vilnius case, which in 2011 showed that the right to free movement and non-discrimination upheld by EU law could not be put into discussion because of notions of national identity and belonging. The Court of Justice will not bargain with those core principles and values which exemplify the European Union's own autonomous identity. They pose red lines, leaving little to no room for maneuver and concession, and where adaptation is typically only one way, hierarchical, top-down. Other examples include good governance, rule of law, judicial independence, and democracy. The Court of Justice rulings on these matters expose the tensions, controversies, dilemmas faced by member states who may see them as an encroachment on areas of national competence, sovereignty, and national identity. They may even lead to polarization of affected EU citizens. And these tensions are the birth pains of the process of development of an European Union identity as it autonomously detaches from the grips of national identities of member states, but for which process member states freely signed up to. In the Maltese preliminary reference procedure, Repubblica versus Il Prime Ministru, mentioned by my colleague here earlier on, while the Court of Justice found that Maltese law on judicial appointments did not breach EU law, at the same time it held that, and here I quote, under Article 49 of the treaty, the European Union is composed of states which have freely and voluntarily committed themselves to the common values referred to in Article 2 of the Treaty on the European Union, such as the rule of law, which respect those values and undertake to promote them. A member state cannot therefore amend its legislation, particularly regarding the organization of justice, in such a way as to bring about a reduction in the protection of the value of the rule of law, a value which is given concrete expression, inter alia, by Article 19 of the treaty. Against that backdrop, the member states are required to refrain from adapting rules which would undermine the independence of the judiciary. This Repubblica case was followed by another one, C-204 of 21, Commission versus Poland, the Independence and Private Life of Judges of 2023, which stressed that the value of the rule of law is an integral part of the very identity of the European Union as a common legal order and is given concrete expression in the principles containing legally binding obligations for the member states. But quite apart from the non-negotiable and non-derogable core principles, while European Union law applies, or rather should apply to all member states alike, experience and good sense show that it does not have the same impact everywhere. As a judge coming from the smallest member state, I know how unique, fragile, distinct and vulnerable national identity is for small member states in the periphery of the Union, where impacts and challenges of European Union law integration are amplified by geographical, social, demographic and economic realities. Through dialogue, member states and European Union institutions seek to strike the difficult balance by adapting laws to cater for the unique circumstances of small member states. By securing some degree of flexibility within the framework of uniformity of European Union law, some of these impacts and challenges are countered by national margins of appreciation or national carve-outs. Examples include territorial cohesion policies, seeking to minimize the size and geographic disadvantages faced by small island states, certain concessions in the manner of application of state aid rules, structural funds, public service obligation, fishing industry and the like. These are actually more common sense measures based on logical considerations that some leeway is indispensable for small nation island states to keep their essential services running, such as transport and energy, for example, which would otherwise be unsustainable under strict European Union competition rules and which could even pose an existential threat. This good sense approach was also adopted in some cases by the Court of Justice, which interpreted EU law in this specific context in mind. And indeed, context is king. So whenever legally possible, and in specific cases, constructive dialogue between national judges and the European Court helps to foster better appreciation and understanding of the context of the diverse specific needs of different member states and their different national identities. While keeping an eye on the red lines, this process helps to make the interpretation of European Union law more transparent, better accessible and understandable by the ordinary citizens. This is a process which in turn further contributes to development of a healthy and autonomous European identity, bringing the aspirations of its people closer to the European Union institutions, its law and its interpretation. It helps citizens to gradually acknowledge that they are protagonists within the Union and come to feel the Union's identity as part of their own. It is a process that attracts people of the Union closer to it rather than alienating them ever so more from it by making them feel disconnected and detached from the policies made or decisions taken. It is a process that should strive to instill the conviction in Europeans that it is still worth it to be part of this union, being an expression of a common destiny, an essential component in the present and the future, a process that should make Europeans feel and call the European Union home. I fear that we are still not quite there yet, but I am convinced that given enough time and determination, through the indispensable tools of dialogue and adaptation, an autonomous European identity will consolidate as based on those European ideals that are still relevant today in the troubled times that we are living in, as much as they were a beacon of light and hope for Altiero Spinelli and Ernesto Rossi on that isolated tiny Italian island of Ventotene during the Second World War. Thank you so much for your attention.
Thank you, Judge Bugecha, for the great presentation and reminder of values. Dear colleagues, we have covered all the 4 presentations. We have exceeded our time limit a bit, but it cannot be any different when we speak about identity. We cannot do it in a hurry, and it's not simple. And this reminded me of St. Augustinus, who wrote in one of his texts that I cannot define who God is. I cannot list any features, but I can say accurately when God is disrespected. And I think it's similar when we speak about identity. We cannot provide a comprehensive list of all the elements, but we will definitely feel when our identity is infringed. And I think that's the issue in the dialogue between national courts and the European Court of Justice. I would like to quote again in this instance St. Augustinus. This is not by chance. This is related to a book I'm writing now. Unity is important in substantial things, and in details, freedom is what matters, and love is overarching all this. If we have all this, we will celebrate also the 600th anniversary of Kant in uniform Europe, where identity is guaranteed. And I can invite you now not only to the 600th anniversary of Kant, but also to lunch. Lunch will again be served in the next room for us to enjoy, and we will continue at 2:15, and we will continue according to our agenda. Thank you to presenters, thank you to everybody.
Ladies and gentlemen, dear participants, it is 15 after 2, and this is one of the rare conferences where we strictly stick to the time. I urge to start our afternoon discussion. I'm very honored to be invited to moderate this afternoon discussion panel with a topic of European Union law in daily work of a judge. I think this is a very good block fruitful conversation after first two discussions where we've tackled both conceptual and philosophic issues. From my perspective, I would like to stress upon two issues. The topic of the afternoon discussion will directly relate to the responsibilities of national judges about values of the EU, which has been several times already stressed, as well as throughout this month, through which we celebrate accession to EU for 20 years. But at the same time, every national judge is also an EU judge, an applicator of EU law. EU law is applied in Riga, Prague, Ljubljana, and as our president said, national courts are the most important EU courts. And the second thesis that I would like to tell you about the mantra that we keep reminding ourselves about, that this is the responsibility of national judges, application of EU law. It reminds us that EU law is related or closely linked with national law. We cannot talk that I will make a judgment based on my national law and then I will see whether it does not contradict with EU law. No, it has to be applied simultaneously. And second mantra, what Maltese judge mentioned, it is confirmation that we have joined the EU space of law voluntarily, and due to this voluntary joining, we can kind of step back from our national law. And we are also ready what is happening with EU law, because this is our law. We are not just consumers of EU law, we are also the formers through preliminary ruling, through formal, informal dialogue of courts. I return to the thought that EU law starts at national level and its application as well. And all four speeches during the next hour will give you a different, but at the same time uniform point of view how a daily life of national judge looks like. The first speaker has joined us remotely, Mihail Bobik. I am very glad to see him here, the judge of the Supreme Administrative Court of the Czech Republic, former Advocate General at the Court of Justice of the European Union, and he will talk about the just role takers and troublemakers and searching for a positive CEE legal contribution to EU law, how our national law impacted EU law. We already heard some examples of the significant or golden case law stemming from preliminary ruling request from Latvia, but this discussion could be very good continuation. Second speaker will be Andrej Kmetl, judge of the Supreme Court of Slovenia. He will share his insight on the project of IT justice, improving the quality of justice in Slovenia. And the last two speakers will tackle at the topic that was already discussed, namely preliminary ruling. Anete Kovaļevska, senator of the Supreme Court of Latvia. She will talk about the question of preliminary reference submitted to the court, whether it's a necessity or just lack of knowledge of a national judge, and Jānis Jētma, the judge of the Tallinn Circuit Court and advisor at the Supreme Court of Estonia, will talk about preliminary ruling, recent case law of the Supreme Court of Estonia. Every speaker has about 15 minutes, and for us to be on time, comply with the time allocated. Without due delay, I will give the floor to Mr. Babek.
We are very pleased to have you with us. Please, you have the floor.
Thank you very much indeed. Good afternoon. I do apologize immensely for not being able to be with you today in Riga. I did, however, do my due diligence, and I Googled the House of Black Hats and the beautiful environment you find yourself in, and only to my immense regret, I must pop in the next time I am in Riga. Today, my contribution for today might be perhaps somewhat unorthodox, seeing the conception of the conference and also the other topics within this panel. Just to explain, I mean, of course, celebration of 20 years of accession to the European Union are upon us in all the member states that joined in 2004. And I actually participated in a number of those already. And when thinking about what to usefully talk about, I thought to do something slightly different. Because, for instance, us in the Czech Republic, we would be certainly celebrating our accession to the Union, and when looking at the legal impact it did have at us, the Czech law, Czech judges, and so forth, we of course, well, based on the political outlook of the speaker, we look either at all the great achievements and all the changes that Union brought to us, and we look backwards of what has changed, how we have changed, how much law has been changed, the practice of the courts, the number of preliminary rulings, and so forth. So we celebrate the positive contribution, and or, I mean, really based on the political outlook, we also hear a number of negative voices, okay, of also the negative side of what free movement has brought on and how economic is doing or not doing. But in both cases, or in all of those cases, it's really top-down Europeization, meaning we look at Brussels or Luxembourg as the capital, and we look at the incentives it gives to us, and then we reflect in retrospect how we have changed or what opportunities we gained in retrospect. So in a way, as an academic inquisitorial venture, it's a study in top-down Europeization, okay? How the local reacts to the central. What I would like to talk about today is a bit the other direction, okay? Because, of course, at the level of political speeches or diplomatic judicial, we always celebrate the contribution. And it's always being said, oh, well, the member state that joined in 2004, they all of them brought with them their distinctive judicial or legal cultures, and thereby they enriched the union. We are very close to united in diversity and eternal love. The problem is, the more heretical inquisitorial type in me started asking, so, okay, what exactly did we bring to the table to the devolution of EU law and legal institutions, with the exception of bringing our own legal culture and enriching by being rich and diverse, which appears almost a treason. So, what I would suggest doing today in my remaining 15 to 20 minutes is really to suggest, or rather to invite you to think, what have we contributed? And please do not take me wrong, I am no Orbanist or Kaczynskis who would be singing praises to the uniqueness of the East and the decadent West. No, 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 no. My agenda is not at all political. It's really an analytical exercise of going beyond the proclamations of we have all been enriched by being grander, and try to zoom in at what we, by we here I mean the Central and Eastern European member states that joined in 2004, perhaps with no distinction being made, but perhaps with the exception of Malta and Cyprus, which did have slightly different history. But essentially, the post-communist bloc that joined, what did we actually contribute in terms of evolution of EU law? And of course, I do not disguise that in academic terms or quantitative analysis, this is a very difficult exercise to do in law. Why? Well, because both at the end of inception, meaning when EU law is being drafted and negotiated, but above all drafted, it's rather the faceless apparatus of the Commission when tracing down positive national or influence in terms of national legal thinking might be difficult. And it's even more difficult at the level of output or adjudication, because of course the Court of Justice as a continental jurisdiction, meaning no dissenting, no concurring opinions. Of course, we will find out who eventually was the reporting judge, but how much he or she, coming from a certain member state, contributed to the actual solution and how much he or she influenced the thinking with his or her mindset is rather difficult to reconstruct. And I became acutely aware of this very recently when I reviewed a volume which was just recently published, which celebrates the contribution of British AGs to the court and to shaping EU law. It's a volume which was published last year, and I quote, the title is Shaping EU Law the British Way, UK Advocates General at the Court of Justice. And I understand what the authors wanted to do, to pay tributes to the UK AGs once they have left and the United Kingdom left the Union. But how do you actually single out national influence? That's much more difficult. I mean, when my learned friend A.G. Sharpston saw the volume where she was being commemorated in, she started immediately objecting to the very notion that there is an English way of being an AG, okay? The culture translating into the judicial function and then translating into the decision-making. So it is a very difficult exercise, and I can't offer but really my personal feelings and impressions as both insider at national and European level over the past 20 years. So what have we brought? Of course, I shall try, and that's my last remark before going really into the flesh, is I shall try to look more at the positive or neutral side of things, okay? Influence and impact. Because how can we define the influence or impact of Central and European countries, Central and Eastern European countries at EU law? Of course, unfortunately, over the past decade, the view from the West would have not been overwhelmingly positive. If I simplified to the brutish core, it would be, well, look, those Central and Eastern Europeans who haven't got their institutions straight, Poland, Hungary, partially, unfortunately, Romania or Bulgaria, and are just, as my heretical title of the contribution indicated, troublemakers who brought problems to the table, but not much of a solution. And of course, one can try to counter that by spinning it and trying to sell the negative to the positive, right? By forcing the Union to define its own values, the thing it stands for, the standards of rule of law, and being obliged to do so, well, one is obliged to nail their colors to the mast, so to say. It's also a positive contribution in a way by being explicit about something. Nice, but might be a bit more cynical. The other way of going around it, one could really look and see clusters of importance and clusters of interest. Of course, by tabling certain questions through the preliminary hearing procedure or bringing them in direct actions to the Court of Justice or before the Union institutions at large, one tables certain interests, certain principles, certain issues. And you, I understand most of you being national judges, you know very well that a train will be running on the tracks which they are. So it cannot be underestimated the importance of a national judge in setting the rail tracks for the court to run upon. Translated, one could look backwards, and there are some studies looking also in the new member states in particular, looking at the questions they bring to the Court of Justice and thereby set the questions and agendas, such as, for instance, Bulgarian criminal courts, especially the lower branches or the specialized ones, would in recent years be very fond of the EU directives on criminal rights and the rights of the accused and so forth. And when you look at the overwhelming number coming from within a given jurisdiction and tabling certain questions, and of course, once already framing the case, putting it in a certain direction, then you can really see a distinct Bulgarian influence on the evolution of EU criminal law. Similar example, Slovak courts, or in particular the district and regional court in Prešov, which is a sort of mid-Slovakia town, are very fond of points on consumer protection. And you really see an avalanche of cases coming on loans, in particular loans provided by non-banking institutions, the question of currency and so forth. And in this way, you see a cluster of interests which they translate into influencing the law by developing it in collaboration with the Court of Justice further. But let me go to really the three elements which I singled out when thinking about contribution and impact that our post-communist, if you will, legal culture did have at the evolution of EU law. And really, these are just my 2 pence, and I'm not saying they are not others, they certainly are, or that they are the most important ones. So, first, in my feeling, what the Central and Eastern European countries brought to the EU table, especially in the judicial terms, is, I would say, nudging the system into a more intense and searching judicial review, in particular for protection of fundamental rights. And this is a simple diachronic comparison, when one looks before the accession of 2004, earlier on, when in the good tradition, the Court of Justice would have never annulled virtually anything, and the last 10 or 15 years. And of course, what the EU 2004 aid brought with them is a very different mental mindset towards the appropriate balance in between the judicial oversight and political choices. Because all of us, with I think the honorable exception of Estonia, would have in one way or another in 1990s took over the much more assertive German-style constitution judicial review, one. And two, we would be also, especially for instance Czech Republic, but a number of other states in the region in the 1990s, like on a running basis, we would be annulling legislation. No big deal. And of course, when you arrive with such a mindset towards a much more conservative institutions, where such an assertive review would perhaps not be the norm, then of course it's likely to change the median of the appropriate balance and the, how shall I put it, judicial distrust translated into judicial review. So that might be tentatively one element which really countries coming just out of a first wave of deep transition and being used to much more thorough review could have brought. And that's very culturally dependent. Depends where you put the median, okay? Some of you might have read the discussions about activism and the appropriate judicial function. The opening of those would be Hjalte Rasmussen in early 1980s, who would be looking at what the Court of Justice would be doing up until then and call it, I quote, revolting judicial behavior for its intrusiveness. Because he was a Dane, and judicial review in Denmark would be virtually non-existent. If that's your median with which you come to the European level, then of course you are unlikely to be very intense in judicial review, as opposed to somebody, as I said, coming from a very different post-transformation tradition. And this is really deeply mental. I will close this point by giving you an illustration, which I can, without revealing any secrecy of deliberations. It's the mindset. When I was, for instance, because I was the AG for a number of cases dealing with soft law and the judicial control of soft law acts, which have been on a rise in the recent decade or two within all EU institutions and in particular bodies and agencies. And I realized when I look at it and see a European body or institution issuing soft law while they have legislative powers to do the same, I immediately became distrustful. Why are you doing that? And distrustful at the way of avoidance, legislation by stealth, avoidance of legislative procedures and so forth. Because that's perhaps my mindset, who I am. By contrast, when talking to judges or colleagues from the north of Europe or west of Europe, they start from a completely different mindset. And they would come to me and say, well, look, Michal, what's wrong in a complex world of business regulation or fiscal discipline or banking supervision where nobody knows what the rules are, when the agency steps in and gives you the guiding hand? They provide the practice, tools, ideas, guidelines, how to proceed. And I realized, oh, well, look, yeah, we come from completely different directions. What is being done here? And of course, that mental mindset translates into your vision and then into the assertiveness or the quality or depth of the review, not necessarily quality. So that's my first point. Perhaps more searching judicial review was a contribution of our region. Of course, there is a number of other variables, such as increase in secondary legislation over the past 20 years, and or the coming of age of the Charter as binding primary law. We can discuss it for a long time. The second impact, I would say, or the second issue, we might have had an impact on both in adjudication but also legislation in lawmaking, would be really, and I can only label it as individualism, both in economic terms but also social terms. And the balance which translates into that, into legislation and adjudication, in where is the balance between the individual and communitarian. In economic terms, it would really be this wave of all libertarianism of economic freedoms and being more on the type of freedoms than regulation, coming from areas like posted workers directives, role of the unions and syndicates, Viking Laval, and so forth. You see really after 2004 a whiff of perhaps more liberal economic outlook, which of course, however, was changed after 2008, 2009, and the avalanche of crisis. But it's perhaps more visible in the social area and the vision of things like equality, social justice, and so forth. And just to give you one example, to me, epitome of this would be when one reads the decision, actually this time around, of the European Court of Human Rights, but there the dissenting opinions are displayed. And there, if one reads a decision from 2007 or 8, I think, it was called DH and the Czech Republic. It was the Grand Chamber of the European Court of Human Rights, and it concerns the question of segregation of Roma children in elementary schools. And why I'm mentioning it, I won't be going into detail, but there, essentially, the Grand Chamber of the Court said there was structural discrimination, but it was, in their view, a more question of indirect and statistical discrimination, not the individual harm to individual people. And in there, you will see beautiful split where the majority of the Grand Chamber are the judges from North and West, and a number or most of the Central and Eastern European judges are dissenting, and clearly voicing a completely different vision about what is equality about and how far can one push the question of indirect discrimination and statistical evidence. Very deep cultural legal split, if you will. And my last point for today, which I would be offering you as a tentative delineation of an area where the Central and Eastern European countries did have legal impact, is actually the question of authority, and in particular, judicial hierarchy. Because we, in our region, we appear to have problems with hierarchy, especially with judicial hierarchy. And what came after the 2004 enlargement would be questions or requests for a preliminary ruling, which up until there were not put in such a way. I will recall cases like Cartesio, an older Hungarian case from 2008, which actually concerned appeal against an order making reference. But there, within it, a question, am I bound by a decision of my appellate court which questions my order for reference? But then it became even more explicit. Bulgarian case of Elchinov or the Slovak case of Kryža. And in those cases, for the first time, the question was really, I mean, the fundamental question was put out there in the open. If I simplify it, am I bound by my superior court if I don't agree with their interpretation of EU law or I think they are wrong? And of course, the answer from the Court of Justice in view of the system was no, you are not. And it was not surprising. It was there already in the 80s, 90s, and 70s. The difference was, it was never put in such a striking terms of directly challenging the authority of the other court. It would always be, when you look at the older German or French references, where within the system one disagreed with other, there would be a question of substance. And by giving the answer, the new interpretation of the substance would supplant the previous one. The higher court would accept that, and the system would have moved on. But we, Central Europeans, we essentially started popping at direct institutional questions, which of course reached a completely different dimension in the most recent Romanian and other cases. But having externalized that, we really started, well, it was shown that we have very little authority, I mean, respect for authority internally. And there it was really just a question of time where lack of respect for authority internally gets externalized. And that's really, I suppose, the most lasting contribution, at least the Czechs did, to the EU legal order, is that the Czech Constitutional Court in 2012 did what, well, the Germans have been theorizing about for decades, namely to declare an act of EU law ultra vires. Okay? Essentially, I mentioned both of them together because they are connect vessels. Okay? It's problems with authority. And it was translated externally, and by that, really, by somewhat twisted Star Trek scenario where we Czechs were first at something and we boldly went where nobody has gone before, a completely new chamber was unlocked in EU constitutional law. We actually, I mean, you might recall that after the Czech Constitutional Court, it was the Danes, it was the Germans, unfortunately completely new dimensions were the Polish questions, something happening in Hungary and Romania, but so forth. But I'm closing, yes. But we open up a completely new dimension, and we don't know where it will be leading us, the new institutional settlement. Will it be simply the ultra-virus declaration and avalanche in the member state? Does it simply mean a continuation of dialogue by more assertive means? Or are we looking in a longer perspective at the transformation of the union? I don't know. We might see in another 20 years at another conference, but what is happening and might be happening is really still unfolding. The only thing which remains clear is, and that's my closing point here, well, it was the Central European contribution here, because in spite of having theorized it in the German or an Italian constitutional courts in the 1970s, it was really in 2000s, 10s and plus, it was all set into motion in Central and Eastern Europe. Thank you very much indeed, and I would be very much happy if you think of a contribution we in Central and Eastern Europe brought to the table in terms of shaping EU law. I should definitely take on board. Please drop me an email. I should be very happy to include. Thank you so much.
Paldies Bobek kungam par.
Thank you for this presentation, and it's food for thought for us. The question I have written down for myself is how far experience of the East European countries has affected what questions we ask, and whether questions we ask to EU institutions make them look once again at topics which seemed like decided already. Thank you. I assume that we will be busy with these matters also in future, and this is not the last time we discuss them. As I mentioned, our next speaker is Judge of the Supreme Court of Slovenia, Mr. Kmetzel, who will share experience on the project IQ Justice.
Thank you very much. Let me begin with a very simple statement. I can easily relate to most of the experience around the period of accession to the EU that were described by previous speakers. Let me just mention some of them just to set the concept, the context of my presentation. First, there was the solution of the common state. Then there was a big, huge change of the political, also of the judicial system. Then probably for all of us came maybe the only one, but definitely the first reformation of the judicial system, or reorganization of the judicial system. More or less consecutively, there was a huge change of the legal system. Practically no law remained the same. After that came the accession to the EU, and with that another wave of changing the laws. Now we all remember the consequences which we faced as well as we could. Mostly, and perhaps the most visible consequence, was the huge backlog in practically all the states that are concerned, at least as far as I know. But I am not talking about this period. I am talking about the direct consequences of this period. Namely, by the year approximately 2014, 2015, my country was somehow capable to overcome most of these obstacles. Now, what was the situation in the period I am trying to describe? As I said, backlogs were mostly the thing of the past. The self-governance of the judiciary was ensured also by new wave of legislation, which ensured the transfer of several of responsibilities from the Ministry of Justice to the judiciary, including some organizational issues and most importantly the budgetary issues. The European Commission acknowledged that Slovenian judiciary made huge leaps forward, and that we more or less fulfilled all the criteria for, let's say, a judiciary of civilized land, let's put it this way. The legal quality of the judgment was not a problem either. It was verified in several ways, so one would think everybody lived happily ever after. Well, not really. The problem was that almost everybody was unhappy. The first alarm light came from the regular taking of public opinion, and it showed that the judiciary had the lowest esteem in the eyes of the public historically, ever. Just after the gaining of independence, we were, I think, the second only behind the firefighters. And throughout these years, we have fallen several steps even under the government, which is traditionally not in high esteem in new democracies. So, what to do? Well, the first clue was to be found in exactly this data. This data was gathered by the methodology of CJEU. I think many of you may be familiar with it. It is a very complex methodology for measuring the public opinion on judiciary. And what we found out was that the general public mostly rejected the, let's say, idea of their own judiciary. However, the closer a person got to direct experience with the judiciary, higher their opinion was. The parties to the procedures had, by huge margin the best opinion of the courts. So we must be doing something right. In that regard, a series of discussions was initiated by the previous President of the Supreme Court, and, well, a number of issues was identified. It turned out that it was not just the public who was dissatisfied with functioning of the judiciary. When I say functioning, we shall say some more words about it later. It was also the judges who were unhappy. I mean, they had, at least on the first sight, no reason to be unhappy. They were successful. They have eliminated backlogs. Their legal aptitude was, well, widely acknowledged. And then it went on. It turned out that also court staff is quite unhappy. That they think that it is relatively difficult to work for the judges, that they lack the appropriate skills, that they lack the appreciation that should be there. So what turned out was that it is not only the quantitative factors that should be taken into account if you want to make a good, accepted judiciary, which will also be an appropriate working place, be it for the judges, be it for the court staff. And I think it is a good opportunity to present this experience here about what we did, because we are talking about also human qualities, about the values. And this is mostly about the human values within the judiciary, or the human values that judiciary has to project towards the general public in order to be accepted. I mean, it follows that old maxim that it is not enough for the justice to be administered, it has to be seen to be administered, or I should say it should be felt to be administered. So a number of project goals was identified. It's a tall bill, it's a long list, but what does it say? I mean, I won't repeat it here because I will try to be as brief as possible. I would really appreciate some questions, some debate afterwards. It turned out that whatever we do, it would have to be comprehensive. There is no isolated reason for the situation such as it was. Whichever reason, isolated reason, you may try to address, it will only perhaps improve or change a very small segment of the problems. So we have to go to move frontally to address a number of issues at the same time. A certain organizational structure was set up consisting of steering committee, comprising of judges from all the levels of the courts, which turned out to be extremely important. And this steering committee presented the connections of the project to most of the stakeholders, upwards to the President of the Supreme Court, to the Ministry of Justice, and downwards to the last member of the court staff, which were also represented. So there then the activities were divided into three groups. The first one was judicial skills, the second court staff skills, and the third one user experience or public relations. Again, these are very general areas, but I will try to describe every one of them. It will be perhaps, or it has all the potential of being interesting on the, let's say, range of phone book. That's why I will also try to be as short as possible. But judicial skills group first try to identify the needs. The most common comment by the judges was that they felt being left alone. We all know that this is a lonely profession as it is, but here judges were felt to be left alone, let's say, to undue extent, even as far as the transfer of skills or transfer of knowledge was concerned. Development of skills, I mean, it's not just knowing the law. It is knowing how to apply the law in everyday situations. So what the working group did was the President's team of the President of the Supreme Court visited all the courts in the country and held extensive talks with the judges. I was present at 2 of such meetings, and I must say that they were really open. Everybody felt really compelled to relate with their problems. It helped create a long list again of what could be done. The second one, what in my view was even more important, were extensive interviews with new judges. What do new judges miss? What is the most difficult thing that they have to overcome when they become judges? On the basis of that, a number of deliverables was considered. The first one, which is extremely important, at least in my view, procedural manuals for various legal fields. So, as we all know, there is a huge gap between the, let's say, formal arrangements in the law and the everyday work of the judge. These manuals try to bridge that gap, to address as many as possible of everyday situations and to help judges with practical information. The next one, manual with practical information for new judges. I mean, new judges mostly faced very, let's say, uncomfortable situations in the first several months of their serving. From the question whom to call if my computer fails, to the question how do I reserve a hearing room if my is being renovated. I mean, I'm just making this up, but this is a typical illustration for that. And 2 programs for relation of experience. The first one was mentorship programs. A number of mentors were trained, and I think in the first 3 years 30 mentorships were established for new judges, and those were extremely well accepted. I can tell some more about it later, but now I will try to cover as much of the project as possible in this limited time. The next form of transfer of knowledge were so-called supervision techniques workshops. That means an appellate judge assembled a group of the judges of all the instances and prepared some of the issues that he perceived to be problems in a certain legal field. And they openly discussed these problems, because one of the greatest, let's say, shortcomings of the functioning of the judiciary on the human level was lack of communication between judges of different instances. On the first side, not something that would be really necessary, but in reality, very, very constructive, very, very necessary thing. And it turned out, of course, that the number of rejected complaints or of confirmed judgments increased almost immediately after these workshops. It was not a dictate, mind you, in such situation do that. It was just open debate about the issues of law that obviously needed to be discussed. Okay, let's jump to just shortly to the working group for court staff skills. Again, some training programs were established, mostly online training, but also mentorship among these court staff members. Here we have some impressive numbers to report on. In the first year, over 500 employees got involved in e-learning, and we could demonstrate over 300 trained mentors. Again, a huge number of mentorships for the new employees, and there is now an established procedure for a new court staff employee. From the package they receive with all the information to the opportunities of training. Perhaps the most interesting component of the project was the component of user experience or public relation. Here we relied heavily upon not only quantitative measures of satisfaction of public. It was not just counting how many and how many agree with something and how many oppose to something. It was the question why. That means qualitative assessment. That means that extensive phone interviews were conducted with the members of general public. And also what I found amazing at first, but yes, probably the right thing to do, there was an analysis made of public, of the internet media, of the social media in the internet. There are a number of user experience that are related in those media, and there were some very good data got out of it. Now, what are the outputs of this component? Extensive, let's say, inclusion of public. First, many publications, folders that are available at the courts which inform the public on their rights, on the, let's say, basic characteristics of individual court procedures. A very comprehensive website that is very frequently visited by the public. They can get most of the, let's say, basic instructions how to go about the court procedures or whatever else they need from the court. And of course, we try to keep up this relationship with the public. Let me just briefly mention the results. Target public within the judiciary had extremely good evaluations of it. I think that the average is some 4.7 out of 5. I mean, this is the combined result from the court staff and from the judges. And, well, as far as the general public is concerned, we have moved again up to the top of state institutions as far as the trust of the public is concerned. As I said, without much, let's say, change in the content of our work. It's simply the presentation, and as I frequently put it, it's simply the respect for the intricate fabric of interpersonal or interhuman relationships, which also have to be respected in our work. Thank you.
Paldies par šo stāstījumu un par.
Thank you very much for your speech, as well as it is admirable what a project have been implemented for well-being of our judiciary system. And it's also important what you've mentioned, the judges feel comfortable in the judiciary system, as well as the public perceives the system better, the system that can be trusted and that is understandable. Anyone can subject themselves by such a system. Next speaker is going to be our Senator Anita Kovalevska. The question for preliminary reference, is it the judge's ignorance or duty to ask such questions? Hello, dear participants. I would like to start with the following. Let me congratulate you with this wonderful occasion. It has been 20 years since we are members of EU together with other 9 countries. 20 years ago, it was an achievement for Latvia, and it was a good basis for further development for us all together in the EU. Accession to the EU impacted the judicial system of Latvia and the work of our courts, because now we applied EU legislation in Latvia as well. It was mentioned very often that every Latvian court is at the same time an EU court that has to ensure application of EU legislation in Latvia, thus implementing all the values of EU in Latvia that are our common values. Of course, participation in EU it has impacted our work in the following way as well, that we can have a dialogue by exercising preliminary ruling. Looking at the statistics, Latvia during those 20 years, or our courts have turned to ECJ 127 times under preliminary ruling procedure. As our President already showed this morning, questions were asked by all level courts: Constitutional, Supreme, District Court, Regional Court. These questions have concerned all branches of law, as well as many areas of different industries. Also, it was mentioned today that Latvian cases have been important for the benefit of other EU countries and have given it their impetus for the development of legal system of the EU. But the question or the goal of my speech, that I was asked to think why these questions are asked, why preliminary ruling requests are being made. So let's start with the following. Why people ask questions to each other? Usually because we don't know something, and by asking a question we want to acquire answer or knowledge. That's why a question can be considered one of the strongest instruments for development and learning. The question can be asked for different reasons as well. Let's say if we speak about universities, schools, questions are being asked whether the student or pupil has learned, has gained knowledge. But sometimes these questions are with a goal, let's say, to foster the way of thinking into a certain direction. Moreover, questions can also show or direct that an assent is needed. The questions might be asked due to the fact that you just honor the person to whom you are asking a question, or on the contrary. The reasons are various. If we think why courts ask questions to ACG, I believe that the individual reasons for the judges to do that are also very, very different. But if we think about court as an institution, the basis of questioning for preliminary ruling is a lack of knowledge. Very often, or sometimes, in Latvia, we encounter that participants of the process are not happy that preliminary ruling is being asked because it will mean more time for litigation. But sometimes we can also hear from parties in a sentiment that expresses, why are you asking? Are you not knowledgeable? Can't you cope by yourselves? I believe that this esteemed audience does not have this doubt or do not have this question. But I here have to start with what has been mentioned already, namely the role of ECJ in EU concerning interpretation of the law. And speaking about interpretation of the law, I have to say that unfortunately or fortunately, the interpretation of legal norms is not an absolute and exact science, and even very competent and knowledgeable people can come up with contradictory opinions. And this is also one of the reasons why our national systems do have hierarchy, where usually Supreme Court has a task of uniform application of the law. I believe that a similar role is there for the ECJ, because if we are all EU judges, we all apply those norms, we need someone who can unify us and our application of EU law. But as we don't have such a system that national court judgment can be appealed in the EU Court of Justice, we have this preliminary ruling procedure. And in order for it to work, the last instance, or the highest instance court has to apply to ECJ in order to ensure that this mechanism actually operates. Thus, If we are talking about Supreme Courts, I believe that no one is doubting that the formal reason for asking preliminary ruling questions, we have this task because we need to apply EU law in a uniform way. If we talk about other courts, let's say regional and district courts that are not Supreme Courts, here I have to remind that also these courts can have an obligation to turn to ECJ. And even if those courts are not the last instance courts, they have an obligation to ask preliminary ruling if they have grounded doubts on a certain norm to be valid, because only ECJ can consider a norm to be invalid. And very often district courts are the last instance courts in administrative breaches, and then the administrative, in this administrative case, district court is the last instance or the highest instance court, and if this district court has a doubt, they have an obligation to turn for preliminary ruling to ECJ. In other cases, district courts and regional courts are not obliged to refer cases to the ECJ, but again, if we look at the statistics that we looked at already in the morning, we can see that our regional and district courts are quite active, as I have already mentioned. There have been 127 requests posed by Latvia, and 38 out of those have made by district courts and regional courts. Almost 30% of all the questions have come from district and regional courts. And indeed, those are not the cases when these courts were the last instance courts. Often those were cases when these decisions were contested. In these cases, when it's not an obligation, but it's a right, then again, based on what has been said, due to individual reasons or due to these two reasons. One, a wish to be just and to solve a case in a just manner, to be sure that it has been done so, by sending the question to ECJ and receiving an answer. This certainty is acquired. And second, if a regional or district court asks this question to the ECJ and then adjudicates according to that preliminary ruling, most probably this decision will not be contested, and justice will be established sooner without prolonging it artificially. And this can be evaluated as a positive trend. At the same time, we have to remind what has been clearly written in the recommendations to national courts on references for preliminary rulings, namely that the question should be referred when the court is able to define with sufficient precision the legal and factual circumstances of the case and the questions of law which arise in the case. Thus, especially for regional and also district courts, they have to be very careful establishing all the necessary information. Supreme Court has a favorable place because the cases have already been dealt with. The district and regional courts have to be very careful because sometimes the answer might not be sufficient due to lack of some facts, and repeated preliminary ruling procedure should be initiated, which asks for additional time and money. I have to say that Latvian courts have been doing quite well, because there have not been any cases when, let's say, regional or district court have asked a question, and then, let's say, the next instance court will have to reformulate practically the same question, but by adding some facts. So even in this case, I do not see that lack of knowledge is the fact why courts ask for preliminary ruling. And second, if we look at this procedure in general, we can say that this procedure asks or requires substantial knowledge from the court and its judges. You have to know this procedure, you have to apply it correctly, you have to identify that the issues are of EU law are dealt with. We have to prove that or see that previous case law has not been established or preliminary ruling has not been passed. Also, ECJ representatives in different seminars urge national courts to enclose their own opinion on interpretation of certain norms. In Europe, there is no unified application to this request. A recent survey made by Association of European Administrative Courts and Councils of the States, it was found out in 2023 that, let's say, Belgium, Bulgaria, Croatia, France, Lithuania, Romania, Slovenia, Sweden, and UK consider that expressing an opinion in the referral decision is not permissible, because in that way the court as if pronounces an outcome or a desired outcome of the answer. However, other courts considered it permissible, do not see any problem, and comes up with their own opinion on specific issues. There also have been several courts that see better quality of dialogue between courts, allows ECJ to come up with in-depth analysis, indeed taking all the aspects into account. Thus, the result is of better quality. In Latvia, we do not see any problem of expressing an opinion already on the preliminary ruling. It is not the fact that our courts are always doing it, but we don't have an internal feeling that we are not entitled to do that. And I would like to express an assumption that it was fostered by the fact that we have promoted access to decisions or ruling of conditional court, namely our district courts and regional courts. When turning a case or turning to constitutional court, they have to express their own opinion on the matter before constitutional court passes its judgment. So this situation is quite similar. To summarize, I conclude that the main reasons why national courts refer questions to ECJ are indeed the obligation or legal obligation for preliminary ruling in order to ensure uniform application of the EU law, but where there is no such obligation, this is just to make sure that the dialogue with ECJ enables a case to be resolved correctly and final solution to the case to be reached quickly. But insufficient knowledge of EU law rather reduces the likelihood that the national court will refer a question to the ECJ. And again, our statistics indeed show that where we see that during first years of our accession there were no questions. The questions were asked when we already gained substantial knowledge on EU law and were able to ask those questions. Thank you.
Thank you to Judge Kovalevska also for answering your question that submission of a preliminary question actually attests knowledge of the EU law, that preliminary questions serve as a tool for constructive management of diversity, to collect EU law interpretation issues at the same place. And as you mentioned, that in the case of Latvia, questions have been coming from all levels of the court, which is good, meaning that this knowledge is not concentrated only at the top-level courts. Now I will give the floor to a colleague from Estonia, also about a similar topic, about preliminary rulings and the recent case law of the Supreme Court of Estonia. So the floor is yours.
Thank you. Honorable panelists, ladies and gentlemen, it is a great pleasure to participate in the international conference dedicated to the values of the European Union. The more time goes on, the more a judge of a member state must, in his or her daily work, apply EU law. On the one hand, this is due to the fact that the scope of the EU law is increasing. What causes the greater need for EU to intervene and to enact new legal acts? Crises are the acceleration engines. Let's think back to, for example, the crisis in healthcare, the COVID-19 pandemic, crisis in the economy, the European debt crisis, crisis in the environment, climate change, crisis in the humanitarian, mass migration, or crisis in security, the ongoing war in Ukraine. Crises that are pan-Union require the enactment of pan-Union rules. The more rules, the more bureaucracy. The more bureaucracy, the more legal disputes. The more legal disputes, the more EU law enactment and interpretation. The more interpretation of EU law, the more preliminary rulings. And that brings my thoughts to the second issue. The European Court of Justice is tasked with interpreting EU law and ensuring its uniform application across all EU member states. When it comes to borderline cases, in the matter of who has the competence to regulate the issue, either the member state or EU, the judges from the European Court of Justice, allow me to be a bit provocative, may prefer EU to the member states. Could it be that in a contested situation, they may prefer an interpretation that expands the competences and powers of the EU rather than member states? There's a question mark. I will analyze some case law examples from the Supreme Court of Estonia. The first case. The person was employed as a prison officer by Tartu prison, and he had worked there for almost 15 years. His employment obligations included supervising, passing on information, monitoring surveillance by means of a surveillance system, responding to and communicating information, etc. His medical certificate showed that the standard of sound perception in his right ear didn't meet the requirements of regulation, and therefore the person was dismissed by the director. He turned to court and claimed that the dismissal was unlawful. The Court of Appeal found that the dismissal was unlawful because the regulation was in conflict with the general right to equality arising from the Constitution. Then the Supreme Court had to check whether the regulation was constitutional and valid. The Supreme Court, instead of examining whether the regulation infringed the constitutional right to equality, asked the Court of Justice for a preliminary ruling. Should directive, which establishes a general framework for equal treatment in employment and occupation be interpreted as precluding provisions of national law which provide that impaired hearing below the prescribed standard constitutes an absolute impediment to work a prison officer, and that the use of corrective aids to assess compliance with the requirements is not permitted. The Court of Justice answered that the national regulation was against the directive. After the Court of Justice answer, the Supreme Court was faced with a dilemma. Does constitutional review yield to EU law? The case had no cross-border implications. The prison officer was an Estonian citizen and he had worked in Estonian prison. In that case, the Supreme Court could have decided the case only on the basis of the Constitution. There was no need to ask for a preliminary ruling. How did the Supreme Court resolve the dilemma? The Supreme Court en banc stated that the mere fact that the Estonian regulation is connected with EU law cannot prevent the review of constitutionality within the meaning of the Constitution, provided that the procedure for a review of constitutionality and its outcome don't jeopardize the primacy, unity or effectiveness of EU law. The possible incompatibility of regulation with EU law didn't preclude constitutional review. The Supreme Court declared the regulation unconstitutional and invalid. Thus, the Court decided the case on constitutional grounds. The second case concerns the payment of deposit in European Parliament elections. It is an ongoing case. A deposit of €4,100 is required for each candidate. The Estonian Greens Party wished to submit a list of 9 members for candidacy to the European Parliament. They had to pay a deposition of almost €37,000, but they only paid €8,200 for 2 candidates. They filed a complaint against the Electoral Commission's decision to the Supreme Court. In an earlier 2010 decision, the Supreme Court en banc had found that the election to the European Parliament was also regulated by the Constitution. This means that the Supreme Court could have resolved the deposition dispute also on the basis of Constitution. But the Supreme Court is going to ask the European Court of Justice for a preliminary ruling on, inter alia, the question of whether a deposit of that amount is in compliance with the Charter of Fundamental Rights. The third case relates to the constitutional hierarchy and jurisdiction of the courts. The Constitution states, district and city courts and administrative courts shall be courts of first instance. Circuit courts of appeal shall be courts of second instance and shall review decisions of the courts of first instance by way of appeal proceedings. The Supreme Court shall be the highest court in the state and shall review court decisions by way of cassation proceedings. The plaintiff claimed damages because the Supreme Court had breached EU law. For an individual, such a right is derived from the Göbler and Traghetti cases. The person filed a complaint with the administrative court. The court of first instance had to check whether the highest court had breached EU law in the administration of justice. Finally, the Supreme Court in its decision also confirmed the possibility of claiming to the court of first instance against the action of the Supreme Court damages. However, this is not in line with the principle of the graduation of the court and the jurisdiction as laid down in the Constitution. In that case, the Supreme Court didn't apply the relevant provisions of the Constitution. In conclusion, when applying the law, the national judge is faced sometimes with the dilemma of how to reconcile EU law with the Constitution. Do we accept the primacy of EU law over the Constitution? Should the High Court disapply the Constitution and delegate its jurisdiction to the Court of Justice? Is the solution proposed by the Supreme Court, giving preference to the application of the Constitution where this doesn't jeopardize the application of EU law, workable in the long term and in all circumstances? Are national constitutions being marginalized, and do national judges have to contribute to this? These are some of the dilemmas that judges must deal with in their daily work. Perhaps the idea proposed in Brainstorm song will help us to solve this dilemma. I will quote, "I will follow my star till the end of my days, and my heart's gonna lead me through so many ways." Thank you.
Thank you, Mr. Jatma, for this very fair presentation, indicating the areas, the fields which have to be focused on, not to turn a preliminary question in a way to shift responsibility and not to turn it into a tool which is not suitable for a legal system. Thank you very much to presenters. We have come to the point, 3:30. We have exceeded only 2 minutes, so we have had great time management. Our afternoon discussion is over. Thank you again to all the speakers. I will admit myself to conclude by a statement. A few years ago, in an event, the chair of the German Constitutional Court at that time describes a dialogue between courts in Europe and the links between European Union courts and national courts. He described it as a kinetic sculpture, so many elements which are interlinked. As soon as one element moves, it affects all the other elements, both on the international level, because the Court of Human Rights looks what the European Court of Justice does, and similar. I think that in today's discussions we saw a good illustration of this similarity, and it will continue, and the court dialogue, the court's interaction will strengthen both the national law and the EU law. Now I have the honor to invite the judge, Ms. Ziemele, to come up with a conclusion. Have you changed? Okay, there will be a joint presentation by both colleagues, Ms. Ziemele and Ms. STRUPIŠS. So you are kindly invited to the scene. Colleagues, so throughout the day we've heard very valuable speeches from different perspectives. Indeed, I would like to thank the Supreme Court of the Republic of Latvia for organizing this conference on the occasion of the festivity, as well as this festive dimension was supplemented by in-depth view on EU legislation, on EU law.
Thank you very much, the Supreme Court of Latvia. Thank you, all the speakers and guests. I will share my thoughts on synthesis from this day, because for me, this synthesis is very interesting, and I hope that you will find it interesting too. First, of course, today here in this room, we had history present. This is self-evident, because 20 years we, quite many of us do remember those days, and we remember what starting points we've had. What was the road to the accession to EU, and the law and challenges we've had, but with quite a satisfactory outlook. We can have a look back and say that we can be quite satisfied what we've done, knowing where we were and where we are. And it was interesting also to hear the experience of Slovenians whom Supreme Court, and I hope that Estonian and Lithuanian colleagues will agree to me that our starting point was one of the lowest ones, and comparing also to Central Europe as well as, let's say, Slovenia and Croatia as member states. So this historic perspective was very present also in our talks about values, and what was outlined when talking about equality principle, about national identity. It was said that EU was created not in 20 or 50 or 70 years, but to EU as European civilization, we have come through centuries with very, very difficult and heavy history. And the idea of EU has been the idea of peace, for which Europeans have fought always. Thus, this achievement cannot be underestimated. It has to be evaluated as it is. After several centuries, thanks to EU and the space for justice, we have relative peace. Although right on our borders, there is an ongoing war, unfortunately. This was the first thesis that I noted. Second, this synergy between member states, history of member states, as well as the construct of the EU. This synergy through the Article 4, Part 2 of the Treaty on the Functioning of the European Union, and what Judge Irgaitis mentioned, it is worth remembering that national identities are simultaneously a renewed, renowned concept of the EU judiciary system. And this is a unique concept in the world. There are no other places around the world where this concept is being applied. That's why the responsibility of judges, both national and EU judges, is huge in order for this unique idea or construct to keep in the right balance, at the same time being ready to move forward. And there have been very interesting thoughts as to where and how we are moving forward. But the question will remain with you, the question that was asked, what is value added to this balance between national identity and unified values in the space of law? We have to come up with an answer. Judge Jarukaitis already gave us 3 answers, but we have to keep coming up with different answers. And different areas, those answers might be different. Colleague Mikhail Bobek asked a question, and I hope that in May of this year we have been thinking about it a lot. What were the values or added value from this biggest succession of so many countries in 2004? When we started the conferences in Luxembourg, we came up with the conclusion that that was a constitutional moment in the EU and the area of justice. It was this was the biggest enlargement, but how the paradigms changed, and they did change. And then further speakers spoke on those paradigms and how those paradigms changed. And you probably noticed that maybe these 10 member states who accessed simultaneously came with an overarching need to ask for preliminary ruling on application of fundamental charter. Our history answers to that question. We have a need to ask questions on fundamental charter regarding several areas of justice. It was interesting also to hear, and we've heard it from Anita Kovalevska, that Eastern Europe first level courts, district courts, are the ones who are very active. That's why this traditional hierarchy understanding on formation of justice system through preliminary ruling procedure is being dealt away with or challenged, because first instance judge can and may ask a preliminary ruling. There have been cases when district court does not want to follow the directions or judgments of the Supreme Court that, according to him or her, are contradictory to preliminary ruling. These are indeed challenges from, let's say, younger member states. Challenge is the right word here. And of course, we have spoken at a great deal about judges, their education, self-education, tidying the judiciary system after collapse of regimes, collapse of totalitarian and socialistic regimes, on how judges have to regain trust from the public, and different mechanisms, how it can be achieved. We all have encountered that in our respective countries. I would like to especially underline one more sentence, namely that national judge as an EU judge at the moment, the knowledge of EU law is the basis or the basic element of his or her legal education. And here I want to underline it one more time. And in those countries where it is not the case, this is the last moment when it can be remedied, because preliminary rulings can be asked only if there is knowledge. And without preliminary ruling, we cannot exercise EU justice system, and we cannot add value for common values, and we don't want to stand somewhere aside when this complex phenomenon of EU justice system is being formed. But in order to participate, we have to have knowledge as well as procedural and other tools. Also, we have to be independent, we have to be impartial. That was mentioned already today. I was worried by one thought that was expressed, that still in, let's say, older member states as well as in new member states, it is difficult to formulate how to say it in Latvian, but what was said by colleague Bobek, that there are different mindsets in new and old member states. This was quite interesting thing, and we have to think whether it's true, or maybe there are some separate cases, but what does it mean if that's the reality? And then the last block or conclusion from me, we of course talk about EU material law, about the lens of common values. We talk about procedural law from a judge's perspective, from national judge's perspective, the applicant of EU law with all the knowledge, impartiality and other guarantees necessary to exercise one's work. But at the end, and here I come to the colleague from Estonia, how do we indeed apply EU law? What can we do, to be honest? And this comes together with what I said this morning. So, dear colleagues, maybe it is worth remembering some key aspects. First, EU Court of Justice, as prescribed by the law, is competent and is responsible for interpretation of EU law. It is the final interpreter of the EU law, but it does not apply national law, the law that is mentioned in the request for preliminary ruling. EU ECJ, of course, can ask for additional explanation of national law. National doctrine is being applied in order to understand how this national law is being applied. But that is being done only to clarify the framework for the issue in the center of the preliminary ruling. But ECJ is interpreting EU law. But national law applies, EU law apply. And how do we apply a law? We cannot just take an article and just somehow apply to the case. Any application asks for understanding of the law and how we as legal professionals can apply a law by interpreting it. But national courts, independently of whatever is the process in your mind of understanding the law, legal activity or legal action is application of the law. This is the second point. Next. Third, Of course, every national court applies EU law according to its competency. But there are differences. Let's say between constitutional court, they have their own competency, but the competency of, let's say, Supreme Court differs from constitutional courts' jurisdiction. So it can be adapted how we apply that. Also, we apply EU law according to our constitutional principles, and it changes quite a lot. Latvia is a representative of monism, and it depends on how you look at it, whether it makes your life simpler or more difficult. Of course, when applying EU law, we ensure its supremacy. But now the key question, how about constitutionalism? We ensure supremacy, but if we have a feeling that it does not correspond to our constitution, or it goes contrary to our constitution, what then? So that's the question. We have to ask ourselves this question. We cannot avoid or be afraid of this question, because a national judge has given an oath to abide by the constitution of any respective country, and he or she cannot be afraid of doubting application of an EU that can be applied according to our national law, but it goes contrary or it goes against our constitution. What do I do then? Then there is a mechanism of Article 267 of Treaty of the Functioning of the EU. I asked preliminary ruling in Article 1 and in Article 2 series, as it was done by Italy. That was done by the Constitutional Court, repeatedly asking the same question by adding additional explanations why, let's say, from the logics of criminal law of Italy, one dimension cannot be directly applied that was previously not known by the ECJ. And then again, we should apply it in order to explain national doctrine and application of that. The constitutionalism should be ensured in the EU in a dialogue with ECJ. And in order to do that, and that is a part of this rather difficult system of justice and its functioning, in order to do that, we first of all have to understand that there is a problem of constitutional character, and we can only understand that if we understand EU law, applying all the methodology, etc., equally to our own law, our own methods of interpretation and traditions. But those questions should be asked. There are no breaches of competency if we do ask those questions. There is no stupidity or laziness underneath. We have to use this mechanism. And the answer replied to by Estonian colleague, we receive a reply from ECJ, and how this reply fits into our justice system. Depending on competency, who has to come up with a judgment and later on enforce the judgment. But this issue can be dealt during the next conference. And at this time, I say thank you and give the floor to the President of the Supreme Court of Latvia, Aigars, STRUPIŠS, please.
Thank you for the very use valuable and complicated summary. Well, complicated not in the meaning that it's not understandable, but complicated as very in-depth and valuable. The idea of conferences is to provide food for thought and development. A conference providing answers to questions is not a valuable conference. Conference is a dialogue. It's searching for answers instead of providing answers. And I think that today we have discussed a lot from different from the perspective of different countries, different experiences, giving us a lot of food for thought. In Latvian, we cannot actually translate this phrase, food for thought, but this is exactly what it is. It doesn't harm our health, so you can consume it in any quantities. I liked what Mr. LENAERTS said in the very beginning. He said that this conference is like exercise in common awareness. This is exactly what we needed. And in the very beginning, President LENAERTS defined it very accurately, because the European Union is a community, and looking for common awareness, looking for common and different, this was our training today, exercise today. Looking back to the experience of 20 years and trying to find the biggest obstacle or the biggest challenge, factors causing the biggest problems, I would say that one of the central issues was caused by perception of the EU law as something parallel to the national law. But it's not actually like this. It's not parallel. Maybe it's not a unified system of law, but this created some kind of illusion for judges that this is where we have the national law, this is where we have the EU law, each court has its own competence and it never intersects. But this is not how it works, and that's why we needed decades to be able to understand that also a national judge is the one applying EU law. And I think the biggest error or deficiency arises from that the EU Court of Justice was viewed as an exclusive interpreter of EU law. It's not exclusive, it's final, and it doesn't imply exclusivity. Any judge should interpret EU law provisions, and if a judge of the first instance national court applies an EU law, he or she has to interpret it. Of course, if we assume that that's the exclusive competence of the EU Court of Justice, a national judge would not be allowed to do it. But it is not like this. And therefore, I would like to believe that the saying I've had to hear, I don't have time to apply EU laws, I have to examine my cases, I think that this saying is past. As regards questions, as regards preliminary questions, I liked very much the presentation by my colleague Anita Kovalevska, where she spoke about cases in which preliminary questions are asked and for what purpose they are asked. And then I remembered, I think it was an idea by Confucio, the one who whether the one who asks a question risks to look like a fool for a moment, but the one who doesn't ask this question remains a fool forever. This can be applicable also to preliminary questions. Of course, one should be reasonable and the right balance should be found there. It's also a question of reasonability. According to this concept, EU court and national courts support each other, because if national courts apply EU legal provisions, the EU Court of Justice assists them in applying these provisions. And what I mentioned in my presentation, an example from Poland, the Court of Justice also defends independence of national courts, and without this support, independence of national courts would be much more difficult to preserve. So it's a very effective interaction for maintaining the democratic system of judiciary. That's briefly all from my side as a summary or conclusion. I would like to thank all the moderators, all the presenters, all the guests of our conference, both judges and staff of courts, also employees of representatives of other authorities and institutions. Thank you to the direct organizers of the conference, that's the administration of the Supreme Court, that's Sandra Lapiņa in particular, the head of administration, and Zane Mičule, who is our project manager. I think that everything was organized very well, and special thanks to the judge of the European Union Court of Justice, Ms. Ziemele, and Jānis PLEPS, for sharing ideas and supporting identification, definition of the content of the conference. Thank you also to our interpreters, and the interpreters thank the audience. Thank you. Now I will conclude the official part, and everybody is invited for an unofficial glass of wine and continued discussions until we are asked to leave those premises. Thank you and goodbye.